Hello, everybody. Happy Tuesday. Happy Tuesday. This is a special edition of Rideshare Rodeo, and I'm excited to have Karen here today, Karen Anderson, freelancers against AB5, and we're going to talk a little bit about this because I've been actually talking to a lot of people about Prop 22 recently, and honestly, almost nobody knows why that's a whole separate issue, but almost nobody understands why Prop 22 even happened. Nobody that I know. Like if we try and get to the root of it, nobody is like, oh, that's because of AB5. They just think that Prop 22 just popped up and here it is. This is going to happen. And well, why would that happen? You know, so I mean, like, I guess it's getting more to the root of the damage that was done by this insane law instead of what the value is to gig workers, because I think I've even talked to you about this, Karen, but I recently had Sergio on for the 300th episode, and we were talking about how really rideshare drivers don't even benefit from Prop 22. It's only the food delivery people. And when they did the carve out, they didn't really know the pandemic was coming. So they didn't know to carve out these extremely low base pay numbers for like DoorDash or Uber Eats. And they just kind of were like, well, you know, let's I don't know, let's carve this out. And then the way it worked, the rideshare drivers aren't really being paid anything, but you can take no tip orders all day long and you'll get 120% of the minimum wage in your area. So like, what is a base pay of $2 or $1 here in Colorado? So you can't do more than 2 dashes an hour. Maybe some people can say, oh, I can get a third in. Okay, let's call it 3. And if your base pay is at $2, then you're going to get 3, and that's $6.
Yeah.
California, even on no tip orders, is saying we'll pay you 120% of minimum wage no matter where you live. Instacart's another good example. You know, Instacart has lowered their base pay from 8 to 7 to now $4 base pay for what normally takes an hour to an hour and a half minimal of your time. So here in Colorado, you're going to be paid $4 to do an hour and a half's worth of work. You shouldn't be dumb enough to take that. In California, you'll be paid 120% of minimum wage.
Right. But minimum wage varies from city to city in California too.
Well, that's what I'm saying, because I think you guys vary from like 16 almost to 20, because there's like San Francisco's like 1988 or something.
No, the Prop 22 included all those quasi benefits and protections. And, you know, from what I understand, the healthcare stipend, you know, is not lived up to what, you know, they promised. And of course that would, you know, come back to bite them when they tried to carve out, they tried to make a whole classification employment law around their own sector, you know, rather than just asking the voters, let us remain independent contractors and leave it at that. Instead, they put in all of these other pages upon pages of you know, legalese and quasi benefits and quasi protections. And some of them make sense to me.
Right. And I mean, there's still, I mean, they do, but I mean, like we were talking about that too. Sergio's in LA and he was telling me how difficult it actually is to get those benefits.
Right.
Like the qualifications are much tougher than I thought. It's not like you're just on the gig app and you get some benefits. That's not how it works.
And I think it's limited to covered California. You know what? I told my partner not to do the leaf blowing.
That's the gardener doing the leaf blowing, guys.
You didn't understand me.
But what we're
I'm sorry.
Perfect timing.
He should be gone in a minute.
Well, we'll kind of just push.
You know, Lorena Gonzalez passed a law that to outlaw leaf blowers. I think it's going to go into effect at some point. I think she probably had a leaf blowing incident during a Zoom call, and she decided to write a bill about it.
So what is the current state of repeal AB5 anyway? Like in your mind, or like how that, is there any momentum there? Is there any?
It's just there's just so much confusion around AB5 to begin with, even here in California, even amongst, you know, media. They just can't keep their facts straight about it. a lot of people conflate AB5 with Prop 22. So they think Prop 22 actually repealed AB5 for everybody or for all gig workers. And
Yeah.
that's how it gets written about and regurgitated over and over again in the media. So it's hard to get people to take things seriously because a lot of the death by 1,000 cuts is happening, like I hear about it in my group, but
Right.
it's just when all the exemptions, there were a lot of exemptions that were added to the bill um, after it was passed 9 months later. And so a lot of the really vocal groups like musicians and interpreters and translators and writers even,
Hmm.
um, and performing artists, they just sort of peeled away from the fight. And so it's really kind of playing out in the courts. We had a really interesting ruling that happened back in March that with the Ninth Circuit, and I could go into detail about that, a little later. But basically, they said that it is probable that AB5 and its exemptions violates the Equal Protection Clause of the 14th Amendment in relation to how the author of the bill, René Gonzalez, was targeting Ubers and Lyft, particularly with animus, built-in animus and bias.
Does anybody really? I don't really buy that she wrote that thing anyway, by the way. Like when you say author, there's so many attorneys that authored that thing. What did she really do?
Well, she
I
she
mean,
was
she
in
just
the
signed her name. She just signed her name to a document,
no,
right?
she was in the mix of it because she was talking to a lot of upset people, um, who, and trying to, I equate her to Dr. Frankenstein because that's what AB5 is. It's just a mess of a mishmash and of arbitrary, nonsensical, convoluted language that has to play out in the courts, and a lot of it, it applies to every single worker and every single business in the state of California. It's not just about Uber and Lyft.
Mm-hmm.
Everybody is subject to AB5 and the ABC test of AB5, which derived from the dynamics decision of 2018 in the California Supreme Court.
Right. So yeah, I mean, obviously that's something that we'll get into here because some of these things that we'll get into, you guys are we're gonna play this through for the Lorena piece because when I interviewed Lorena, and I think Karen, you know this too, like I had all of my questions prepared and I was a little taken off by the answers, which isn't normally my way of being on the lives. Like I'm not used to being so taken. Like, wait, really? That doesn't seem right. And it's hard to call somebody out on that when they're the professor of law or whatever, and you're trying to do an even heeled, try and be neutral party, but when things are just wrong, it just feels wrong. So I thought, I mean, literally, I've said this before. I feel like more than some of your even state legislators and people who have signed on to AB5. I feel like you know more about it than they do, and they signed the damn thing into law.
Well, I've had a front row seat to every last aspect of it for the last 3.5 years. All the
Yeah,
stories that were coming in and all of, and I also like to keep myself really informed. And I will read the opposition viewpoint and their papers and their theses and everything else. I want to know what they're thinking and what they're saying,
yeah,
so that, some of it, they they um they try to pull the wool over your eyes with their excuses.
yeah.
And if you really knew what the dynamics decision was really about, then you would know that using that as an excuse to write AB5 and is completely bogus.
Yeah, and I guess I mean we might as well jump into this piece here because there's going to be a lot of talking points here. But hey, Derek, hi, Ceci, what's up, Rick? Hey, Carnifitch, how you guys all doing? Everybody watching? Excuse me while I'm just playing with my fingers down here. I told Karen I'm trying to get a bunch of glue off my hand, but um, we'll play this piece and then I'll take a break at the breaking points of where Veena stops talking, you guys, because this is why you're going to hear two extreme sides because Karen and Veena do not see eye to eye on this at all, really. This is my point to it is that it's there's a lot to be taken in, but I feel like this piece needs to be leveled out with the other side because if you just hear this alone, it almost might sound like a good idea. even to those who know better. But let's see. So we'll jump in. It's, you kind of got to, in the beginning, we're just getting to know Veena a little bit here. And this was my conversation with her. And then we'll stop at the breaking points unless Karen wants to stop before those. We'll see where we get here.
I'll raise my hand if I hear something. No.
You can't hear that?
Mm-mm.
I wonder why. I wonder if I could just play it off my phone into my mic and keep us in the other view. Let me try that. Because that might be easier, actually.
Well, while you're getting that set up, I want to say that Veena Dubal was sort of a nemesis of the freelancers back when the law was first passed. A lot of people took issue with things that she was tweeting and saying about the law and how it was not affecting us, and so
right.
she's a law professor. She did not.
Yeah. All right, so I'll play. I'm going to play it off my phone here, so it'll go through my mic. I'll be able to see if you have a question that way a lot quicker too.
Okay, great.
So I think now we'll be in a.
Interested in what it meant to be, experiences with working.
Can you hear that?
Men, the sort of things that push them to certain places in the labor market. I saw.
Why did it not work when I pulled it up on here? That should work. Okay, I got one other thing I can try here. Veena Dubal. Well, first, thanks for coming on today, Veena. I really appreciate it.
Oh, I'm happy to be here.
Oh, I know what I'm going to have to do here. So, my research on your background, so maybe I should let you explain. Can you hear me now?
I can hear you.
Oh, you can hear me. I can't hear you.
You can't?
Oh, no, I can, yeah. Okay. So
okay.
Particular sort of struggle.
Can you hear that?
As we were growing up. And
yes, I can hear that. I want to turn it up a little bit.
Experiences with working class immigrant men, the sort of things that push them to certain places in the labor market. And
this holiday season, however you celebrate.
After 9/11, I saw there was a taxi driver in San Francisco who was murdered in what many thought was a hate crime. And he was coincidentally the brother of another gentleman who was also murdered in the first 9/11 hate crime. Is a really tragic family story. And so I was a young college student, and I wanted to reach out to people who were being racialized as Muslim, who were working in the public sphere and sort of document what their experiences were. And so because Sukhpal Singh Sodhi, who had died, was a taxi driver, I started hanging out with taxi drivers in the San Jose airport and was sort of asking them what their experiences had been like. And I heard a lot of really harrowing stories about hate violence and hate language. But what I was most surprised about was that was the way in which these drivers worked. I didn't understand at that point that the way the taxi industry worked was that you had to pay for your shift. You paid for your shift and you paid for your gas and gate system. And that in a period of very little demand, like after 9/11, when no one was traveling and there were no tourists in the Bay Area, workers actually were losing money when they went home. And I thought that was just like a fascinating phenomenon, that in America you could work for 12 hours and go home with nothing in your pocket. And soon after that, I went to law school, and after law school, I started a taxi worker project here in San Francisco, and then did my dissertation on a century worth of taxi worker organizing. And then, as I was filing my dissertation, I started hearing from taxi workers about how there were these, just like 2013, how there were these people in just regular unmarked cars, cutting in front of them at the hotel lines. And they seemed to be summoned there via people's smartphones, and how these people were operating illegally. And I really didn't think very much of it. There's a long history of illegal limo competition in San Francisco and in most urban areas, the black cars. And I thought, well, this is like the black car system, but it's going to go away, because I didn't at the time think it was going to catch on. I didn't think that people would get into other people's cars. And that were largely unregulated. And I sort of thought that the city would put an end to it. And of course they didn't. Mayor Ed Lee, who has since passed, really celebrated Lyft in particular. He even declared, I think it was July 2013 or 2014, Lyft Day officially in San Francisco, and saw this as a way to attract a lot of tech money into the Bay Area. And soon after that, and due in large part, I think, to the connections that these companies, Uber and Lyft's lobbyists, had, the companies were legalized in California in what became the first set of state regulations, I think in 2014, and they created this category called the Transportation Network Company. And what's interesting is that they created this legal category, and there were some regulations in the state that were promulgated by the state body called the California Public Utilities Commission that regulates the transportation network companies, but there was nothing with regard to labor. So even though the taxi workers had been independent contractors, they had regulated fares, they had regulated leases, and they had regulated demand. And as a result, except in periods of really low demand, like post 9/11, or would have been the case during the pandemic, workers were able to make a not bad living. It was unprotected work largely, but in San Francisco, they had workers' compensation and unemployment insurance. And so all of a sudden, cars were flooded. There were a flood of Uber and Lyfts in the Bay Area. Medallions became worthless overnight. And slowly but surely, what we knew was going to happen was wages were going to drop. And that was certainly the case between 2016 and 2018. Wages dropped precipitously for workers in California, for Uber and Lyft drivers in California. And that's, of course, because the wages previous to that time had been highly subsidized by venture capital funding. And so you asked me how we got to AB5. So I know that there are wings of Twitter that think that I am responsible for AB5, but in fact, the way we got AB5 in California was through this decision called Dynamics, which was really, I think, many of us were watching this decision, but what the Supreme Court did was unexpected. And that is, Dynamics was like, it was a decade-long misclassification case involving on-demand delivery drivers. So these were like the guys who delivered Sears, Roebuck.
Yeah, I was going to ask you about this. You put the finger up there.
Sorry.
Go ahead.
Dynamics was a same-day delivery service of small packages and documents, and they 1099'd their employees in 2004 to become independent contractors. And from what I've heard from people who worked there, they enjoyed being independent contractors, and they didn't have, a lot of issue with the company. But they were not driving trucks, delivering appliances and Sears refrigerators. That did not happen.
Right. And I had asked her if anybody heard that too. I'm sure you did, Karen. That I had asked her, like, this is regarding the truckers. I thought this was more of a big rig thing.
No, it was like the Uber and Lyft of small goods. In other words, these people own their own vehicles, and they could take whatever dispatch they wanted to take, and it was
just like freight loading boards and stuff.
So it's like either cargo vans or their own vehicle, and they would deliver small packages and documents, but they were not truckers.
So where are these people then coming from? Where was this movement of people for Dynamics?
Well, it's pronounced Dynamics. A lot of people pronounce it Dynamics, but there was one guy's name was Charles Lee. He'd never done delivery driving before. He joined the company, and he worked for them for 15 days. And then 3 months later, he filed a wage violation claim for overtime. So it was one guy.
Okay. So this wasn't even really a big movement.
No, there was no big movement. According to the people that are in my group that used to work for Dynamics, they 95% of the drivers enjoyed being independent contractors, even though maybe the company was violating the Brillo standard. Who knows? But at that time, they kept prevailing in the court. So she was right. The litigation went on for almost 10 years. But he filed suit. He filed his claim 3 months after only working for the company for 15 days. So some people think that he might have been a plant.
Okay.
Books appliances, and they had been converted overnight from employees to independent contractors, and they were mad because they lost all their benefits, and these lawyers sued on their behalf, and 10 years into the litigation, the plaintiffs won.
Is a quiet determination to be there for our patients, for our communities, for each other.
And the California Supreme Court, in their decision, said, basically, we're tired of companies trying to get out from underneath wage laws.
They didn't say they were tired of this. What they said.
That's not a quote.
No. What they said was that there was not a definition of an independent contractor in the wage order number 9 that applied to the trucking industry in California. And wage orders are minimum wage, rest breaks, and meals and overtime. And this particular driver, his claim was about overtime. And so they had to come up with some kind of definition of what it means to be to employ somebody. So they came up with this ABC test eventually. Now, what Veena didn't tell you is that her paper outlining all of the ABC tests that could be used and applied to this case is cited in the California Supreme Court Dynamics decision.
Do you feel like Veena, do you feel like she's giving me this shell answer? Does she know what you just said?
Yes, because she actually was quoted on her website. I have it right here. They definitely cited my paper, and the quote, the spirit of the paper, her paper, is imbued throughout the decision. So if the spirit of the paper is imbued throughout the decision and the ABC test is simply the dynamics decision codified, then she is one of the architects of AB5.
Right.
Because we have wage laws to make sure that people who work are able to have a modicum of dignity through their work. And so they said, in order to get at this issue of misclassification, what we're going to do is we're going to change the test for who is an employee. And prior to that time, the test that was being used was a test that was derived from tort law, from like 18th century tort law.
You're talking about the IRS test.
It wasn't the IRS test actually.
Okay.
It was called the IRS test is derivative of the control test. And in California, we had a test called the Borello test that came through another California Supreme.
She said we had a test called Borello. Borello is still applicable and in existence. If you don't pass the ABC test of AB5, you're still subject to the Borello test. So it's alive and well. It's gone. It's not gone anywhere.
But if you pass the ABC test, why would you need the Borello test?
Because you could still, the hired entity could still be charged for misclassifying you based on control and direction, which is in the Borello test. So a lot of people, they might have an exemption via AB5, but that doesn't mean, they might have an exemption from the ABC test of AB5, but that doesn't mean that they can automatically be an independent contractor, because they still have to pass the multi-factor totality of circumstances Borello test, which is a much more flexible test, and it's been in existence since 1989, but it's still not that easy to pass.
Right. Okay.
Decision in the early 90s, late 80s, that had to do with cucumber farmers who were essentially, operating under the same business model. The farmer asked them to pick cucumbers. They had to bring their own capital, their own digging equipment, etc., to the fields, and then they got a percentage of whatever the farmer was able to sell. They got a percentage of it after the sale was made, and the court in that case said, these cucumber pickers are employees of the farmer, of the grower. They are not independent contractors, and they created this Borello test. And an element of all of the elements of the ABC test are actually embodied in the Borello test. But what prompted the court to do this, I think, was a whole other set of cases that involved FedEx ground transportation. FedEx home delivery. So in another series of misclassification cases involving FedEx, FedEx lost after what amounted to about $1 billion worth of misclassification litigation. The Ninth Circuit said, using the Borello test, that these workers were employees. And instead of treating the workers like employees, they used the court's decision to redraw their business model. With dental savings such that it looked like to reach out.
Oops.
California was through. Right.
I lost the place. Sorry, guys. I had this all queued up on the other way, and I guess Karen couldn't hear the audio. So let me bring. I hope that's about where we were.
Roebuck. Please, they used the court's decision to redraw their business model such that it looked like they had independent contractors. And so I think to get at the fact that the control test was so easy to get out from under, the Borello test was easy for particularly deep-pocketed employers to manipulate. The California Supreme Court in Dynamics in 2018 said, for wage purposes, we're going to use the ABC test. This is a test that has been used in over half of the states for unemployment insurance laws to determine who gets unemployment insurance and workers' compensation. And now we're going to use it for wage purposes in California.
I had something to say about that.
It became very clear to
she's right that there's ABC tests in other states, but they're not. The ABC test in California is the strictest classification test in the nation because in other states, like she mentioned, it, and I think there's only in the dynamics decision they cite that there's 14 states that use it. I don't know, it might be closer to 18 or 20, but it's generally used for narrow applications. And the B prong, which is so problematic in the California's ABC test, oftentimes is multi-pronged. I mean, it has two parts to it, so it makes it much more easy, not easy, but it's not as impossible to pass as California's ABC test. California's B prong says that the work that's being done has to be outside the usual course of business of the hiring entity. So that would mean a writer like me cannot be an independent contractor for a publishing company or a newspaper because we're in the same line of business. So it's really almost next to impossible to pass.
Yeah, I never really understood why if they were really going for that was the truth, why somebody would even be able to write a certain amount of articles, like how you were for it. Like that always threw me a bit. Like, well, you can write 5 or 10. Like, why would it be any if they're misclassified?
Well, Veena Dubal.
I'm not saying that you are misclassified. I'm just saying, like, why would there even be this?
Well,
that 10 illegally.
Lorena Gonzalez, the author of AB5, originally in the first iteration of the bill, put a cap on writers that we were restricted to only writing 35 pieces or submissions per year for a single outlet or whatever. And so she was thinking in terms of, her thinking was anachronistic. She's thinking in terms of people in cubicles writing, 1,000-word articles for newspapers, and she wasn't taking into account the new way that writers work. I mean, you could burn through 35 submissions with just a couple of blog posts, in a week or even a day.
Right.
So it was clearly unconstitutional, and she did lift that cap.
Right. I feel like that was just, to me, though, that always was like a negative on their own story. Even though it was like, well, you get to do this freely. I felt like by you saying that number,
she gave them an exemption.
You can illegally do 35 a year.
She gave writers and cartoonists and everybody an exemption, but it came with all these different caveats, and that was one of them. So just because they had an exemption, it was partial. And one of the caveats originally was that you could only do 35. So that affected people like weekly columnists. So we had people coming into our group that was like a cartoonist for the LA Times, a movie reviewer for Forbes, and even Willie Brown, who was the mayor of San Francisco, had a weekly column in the San Francisco Chronicle. And when he reached his 35, which is, half a year because there's 52 weeks in a year, he started screaming off the rooftops, what the hell is going on? This is ridiculous. These unions are bastards. I never would have let this pass, because he was a speaker of the assembly at one time. So a lot of people just lost their clients overnight as writers and journalists. And then the LA Times guy was great because he started lampooning Lorena Gonzalez with his cartoons, and we had a whole bunch of cartoons come through that he did lampooning her and her putrid law.
Didn't Lisa make some of those too?
Yes, Lisa made some. We had a bunch of cartoonists making cartoons of Lorena Gonzalez. And in fact, Jim Thompson, the LA Times Sports, former LA Times Sports cartoonist, he did a cartoon of Veena Dubal.
Tech companies, this meant that they were going to have to provide minimum wage and overtime protections to drivers. And so instead of, obeying the law like a lot of small mom and pop businesses did, they decided to try and get out from under the law. And instead,
I have a question about that. She calls the dynamics decision a law, but I was under the impression that the courts don't make laws, the legislature does, and that this was a more of an interpretation of a wage order that came from a state agency. So when she says she's talking about the dynamics decision, it didn't, it was very narrow. It didn't apply to everybody under the sun, because it was just about overtime and wage orders.
Okay.
Assemblywoman Lorena Gonzalez said, instead of letting you get your way, we're going to celebrate this law and we're going to put it into the California Labor Code. So we're going to take it from being judge-made law that the court wrote, and we're going to pass it as part of the legislature and as legislature and put it directly into the labor code. And she extended it. So the California Supreme Court had just had it for wage purposes, and she extended it to apply to.
By the way, that's the second time she said they had just had it. I just needed to point that out.
Clutching their pearls, the judges, and just going, "Oh my God, we just can't take it anymore." No, and the thing about the dynamics decision is that I just found out that, and I mean, I'm just recalling now that even within the context of the drivers at Dynamics, there were certain independent contractors that were exempted from that Dynamics decision within the company, because if you had more than one client, it only applied to you if you were a driver just driving for Dynamics. But a lot of the drivers, drove for other companies. So the Dynamics decision actually exempted so many different types of drivers if they had other clients. So the reason that I'm mentioning this, and it might be in the weeds a little bit, but when so many people from all across the vast swaths of professions lost their livelihoods overnight and were calling their assembly people in their local legislatures and stuff, and just in a panic, what's happening? How can this be? What have you done? You've ruined my career. They would always use the Dynamics decision as an excuse. Well, we had to create AB5 to protect you from the ABC test of Dynamics, because you would have been subjected to it anyways, which is completely false. And it's a trope or narrative that they have perpetuated over and over and over again to this day.
Yeah.
Because that wage orders don't apply to people like doctors and lawyers and accountants and engineers and people that don't, the wages are hourly. It's about hours.
Yeah. Well, I mean, I think that we'll get to that too, because at some point she mentions money, like how much money you're making would affect your status, and that I already know not to be true too.
He extended it to apply to all of the labor code and the unemployment insurance code, which meant that there was a presumption of employment for all workers in California, and that in order for them to get out from underneath the law, if a hiring entity wanted to use an independent contractor, not an employee, they had to satisfy this 3-part test. And critically, they had to prove that the person was doing something different. The worker was doing something different than the usual course of the company's business. And so it was going to be very hard for a company like Uber to say, well, Uber drivers are doing something different than what we, Uber Corporation, are doing. And in fact, when the law was nominally enforced by the appellate court in October of 2020, that is precisely what the court said. The court said, you are a transportation company and your workers are doing transportation work. And unfortunately, we never got to see what that might have looked like in California, because
she said, unfortunately, we never got to see what that would look like. I would say, fortunately, we didn't get to see what that looked like, because the ride-hail companies, Uber and Lyft, and all of them were threatening. They were this close to leaving the state.
Right.
Only 10 days. And that when she said that it was in the court in October of 2020,
Mm-hmm.
That was really, I think, 15 days until the actual election in which the voters would decide on Prop 22 to exempt them.
Right. And and nobody should forget that the Flex Association, which is Uber, Lyft, Instacart, DoorDash, Grubhub, maybe, they put, what was it, like $208 million? It's like one of the most funded propositions.
Yeah, it takes that much to fight City Hall, that's for sure.
So
I mean, they did, and that they were only concerned about their own industry. Prop 22 only applies to them,
right.
nobody else. And the voters voted on Prop 22 in the November 2020 election by a margin of about 58 or 59% to allow them to remain independent contractors. That's the key point. I think there's a lot of people, and your listeners and people in the rideshare community, who view Prop 22 through a different lens. They think of it.
Mm-hmm.
They don't understand that that it's protecting them from becoming employee drivers or having to or forcing the company to make them all employees, which would be a whole different landscape for these companies. It would. I mean, you tell me.
They wouldn't work. We've had this discussion so many times. They wouldn't work under an employee franchise model.
Right. So that's the main key benefit of Prop 22, and the fact that they tried to make it, put on all these other protections and benefits in it, obviously is going to backfire on them at some point, because some people are not going to be happy with it, or it's not going to live up to its promise.
So hairdressers have an exemption too?
Hairdressers? It depends on what kind of hairdresser you are,
See that, and this is where it gets real sad. It depends on what kind of hairdresser you are.
For the most part, yes, they do. But you have to fulfill a lot of different requirements in order to be an independent contractor with a salon. In other words, you can't pass out their business cards. You can't use their products. You can't sell products on behalf of them. They can't take commissions, those kinds of things. You have to just rent a booth, and that's it. And you're in business for yourself. And then if you're licensed. But that's another exemption that has a lot of different requirements to it.
Yeah, I feel like that's the case with most of the.
But then you talk about it. What about a hairdresser who's working on a musical theater production and comes behind the scenes and does something, to the cast members, hairstyles? That person is a hairdresser, but she would not have an exemption from AB5 because musical theater production does not have, you cannot hire independent contractors at all for any kind of, theatrical production.
Yeah.
Companies, of course, passed Proposition 22.
Right. So a couple things there. So the B prong obviously is the prong that most people talk about and have trouble with. And I know that a lot of people, even the non-app-based, non-on-demand gig economy, the more traditional gig economy, caught a lot of people in that net as well. Were those people supposed to be in that as well? I mean, is that, I feel like AB5 initially, like maybe it's just because of the circles I was hearing it in, but I felt like it was very much geared to the app-based on-demand world, not the traditional freelancers and writers and those who needed some carve-outs.
I don't know, honestly. I mean, again, contrary to popular opinion, I didn't have anything to do with the writing of AB5. My sense is that there has been a lot of fear amongst regulators, both in the United States and abroad. So this is a worldwide phenomenon. I hear this when I'm talking to regulators in Europe, in Asia, in South America. A lot of fear that these app-based companies are going to start a sort of revolution in which employment and labor laws have no, just don't matter. And so my sense is that AB5 wasn't necessarily aimed these companies in particular, that it was aimed at a longstanding problem of misclassification. Misclassification has been a huge problem in the janitorial industry, in the construction industry, in the transportation industry, in the trucking industry for decades, since the 1970s, late 1970s, early 80s. This has been a huge issue. But I think you're right that it spoke to a real fear. Like, the time was now, because I can't speak to what the Supreme Court justices were thinking when they wrote the Dynamics decision, but I can only imagine that in the back of their minds, even though they were ruling on an offline company's practices, offline delivery companies' practices, they were really worried about the growth and proliferation of misclassification more broadly, through people or even companies that we call gig economy companies.
Right. I've had mostly, we have guests on the show who are in the what you and I are now calling gig economy, but I have had a couple people from the traditional side too, who even after Prop 22 and before the recent overturn of Prop 22 were caught in that net during this pandemic. I mean, I'm sure that you have heard this 100,000 times too, but they felt caught in a net. Whereas now Prop 22 was letting these people off who I believe AB5 was targeted at, and it didn't let them off, which was, I don't know, that was a hard thing for a lot of people that I had talked to, and it really never made sense to me why they got caught in that.
When you say it didn't let them off, can you tell me more about what?
Well, okay, so I've had one of the guests I had on has a nonprofit, or had a nonprofit opera house in Los Angeles that operated only a couple times a year, and she had been in business for 22 years and in the industry for 35. She was bringing a very unique niche to her opera house based on music of her Jewish ancestry, because through the Holocaust there had been some music lost and it was passed down through her mom. This business has since closed because of AB5.
It's interesting because
a freelancer that I know, and then I know that there were carve-outs too. I do know that in the beginning everybody felt it, because there were even, I remember newspaper people that I know going, wait a minute, what's going to happen?
Yeah.
But I know that they got their carve-out.
Yeah, I don't know. I wasn't part of the legislative process, so I can't speak to all of the carve-outs that eventually were made for all of these different sectors. I do think that there was some hysteria that wasn't.
Okay.
This is very triggering to everybody who it could be, because she has a history of using the word hysteria, dating back to right after the law was passed. You can look at her old tweets, and she was calling us all hysterical and guilty of hysteria and misinterpreting everything and completely dismissing the bloodbath and the carnage that AB5 caused to more than 600 categories of professions. It was like the Titanic. Everybody was thrown overboard, and people beginning in January of 2020 lost their careers and livelihoods overnight. And so when you're talking about life-threatening situations, even for some people who had careers forever, losing their business and their livelihoods, that's not hysteria.
Yeah.
That's reasonable backlash against the author of the bill and anybody who touts it and supports it.
Yeah, I was a little thrown too. If you could already probably tell that she's the I don't knows weren't really flowing with me. Like, I feel like she did know. Like, every time I was saying something, she's like, I don't know.
Well,
I feel like in my head, I'm like, yes, you do.
I'm curious about why she doesn't want to know. Wouldn't she want to know every aspect of how the law is impacting people in order why does she want to have tunnel vision about it?
But she fully supports it. She's on board. I just feel like she knows it better than she says. I don't know.
I don't know.
I mean, how can you be a professor of law somewhere and not have all the details and be fully on board with something?
Because I think she's wedded to her viewpoint, her singular viewpoint about rideshare, to the exclusion of everybody else that's affected and impacted by this law. And she doesn't have the intellectual curiosity or the desire or whatever to learn the totality of the collateral damage that it's caused, all the dolphins in the tuna net, quote unquote, that are caught up in it. She doesn't want to hear about it. She just tells us to pipe down and brushes us off our shoulder and tells us we're hysterical. We don't know what we're talking about, even though we're living and breathing the disaster as it's happening.
Maybe I'll kick this into a 1.25 gear, see if it's too fast.
Okay.
I don't think it will be.
That was the result of two things. One, the result of the PR companies pushing the gig companies, PR companies, pushing hysteria so as to create a mass of people who would, be very angry about AB5 and Prop 22 as a result. And two, I think there was a lot of bad advice that I saw from lawyers who didn't quite understand that there were, even before the specific part.
Gig companies, PR agencies were pushing us to become hysterical. First of all, the gig companies are only concerned about themselves. They never talked about AB5 in the broader sense of it as to how it affects other professions. There were no PR things coming out influencing, the interpreter who was a cancer survivor who lost everything. There were no PR influence over the forensic nurse who could no longer do evidentiary exams on rape victims in hospitals. I mean, it's just completely bogus. It's completely bogus. And then her next thing that she says is that they're getting bad advice from their attorneys. How would she know? She says she doesn't understand the law. She doesn't know the law. Clearly she doesn't. Is she saying that employment law attorneys are giving people bad advice about how to follow a law that actually presumes that everybody's an employee and you have to prove that the person that you hire is an independent contractor, and if you don't, you're going to face astronomical fines and penalties by the Employment Development Department and the Department of Labor Standards Enforcement, Division of Labor Standards Enforcement, and all of these onerous fines and penalties for misclassifying a single independent contractor? No.
Yeah, I mean, I feel like the attorneys would have been the first ones to come up to speed with. I mean, I still, there's a part of me that thinks that she knows more than she's saying here.
Okay.
I'm just, again, when we recorded this, we were doing this on video. So I was watching her. And, there's just reading somebody. And it just seemed like a little elusive for an attorney. I don't know.
It's weird. It's absurd what she just said.
That different groups got, different professions got, that there were ways to structure your business such that you, like the opera business, for example, such that you would not have to worry about this. Like you could structure it as a cooperative, or you could, there are like particular ways to structure a business that you could be exempt. And the reason that I sort of learned of.
No, she's incorrect about that. It's very spelled out clear. It's spelled out very clearly in the law. Musical theater production, which opera falls under, you cannot structure your theater in any which way into a cooperative or whatever she's talking about in order to find a workaround or a loophole from the law and be able to hire independent contractors. Whether if you're a musical theater production, whether it's a worker who works for you for 30 seconds, an hour, a day, a week, seasonally, they all have to be employees on payroll. And so that is why there were so many people coming into my group from the theatrical community, including opera companies. In fact, Gail, the person that you were referencing, was a member of our group.
Yep. And I've gotten to know Gail really well too. I mean, that was probably the initial thing that grabbed my attention was how did this nonprofit that's been a legitimate nonprofit, which is not an easy status to attain either, but how did this legitimate nonprofit get thrown into this thing? I think that's what led my investigation down this.
Every contracting relationship has to be evaluated in detail first by an employment law attorney for its specifics to see if it, if it satisfies all of these requirements, either of the ABC test or the exemption. A lot of the exemptions come with 11 hoops you have to jump through, and so this idea, this notion that you can restructure your business and call it this or call it that, in order to be able to hire independent contractors is absolutely false. And if Lorena Gonzalez was sitting here, she would agree with me 100%. Or maybe she would be duplicitous about it.
Was actually talking to some moonlighting physicians who got letters saying we want you essentially to create your own LLCs, we want you to create your own corporate entities before you can moonlight for us, so that you can't ever say that you are our employee. And while that made, that was one way to get out from underneath it, is just to have everyone be their own LLC, and then they're their own business.
Yeah, I figured that was going to be an issue.
She's incorrect about that. Our group, we found that out the hard way because they were saying, oh, you can be an LLC and be exempt from the law. No, you can't.
Yeah, I mean, that would have been such a simple way out of this thing that there's no way that's
if that were true, then every Uber and Lyft driver wanted to continue to remain independent contractors would just pay for an LLC.
Yeah.
Yeah. I mean, an LLC does nothing to exempt anybody from solely from AB5, nor does it protect the hiring entity who hired that independent contractor who has an LLC of potential misclassification violations. And we have members in our group, small business people, that have been audited and fined for misclassifying LLC web designers who had their own business, had other clients, they had written contracts, they only came into the office maybe once a month, if that, and they still were subject to massive amount of fines, and they had to convert them all to employees.
Right.
An LLC does nothing for you unless you meet 13 other requirements of the business-to-business exemption.
Well, I was going to say it doesn't matter anyway because you'd still have to meet the ABC test.
Well, it depends on if the business-to-business exemption would allow you to bypass the ABC test. But the business-to-business exemption comes with all of these little poison pills about, oh, there can't be control and direction anyways, or you can't, subcontract. And a lot of times it just doesn't work out for people at all, So, but you can be a sole proprietor and take advantage of the business-to-business exemption, maybe. It's just the law is filled with so many landmines and so many curiosities that, and what we're finding out in our group, we're now getting people coming in who are being audited or have completed audits who are actually exempt, supposed to be exempt. And the auditors didn't care. They didn't give one flying fuck that they had an exemption, like dog walkers. I'll show you when we pull up the personal stories. Okay. An architect, wedding photographers.
Yeah.
They're coming into my group saying we're getting audited, even though we have an exemption, and the auditors are telling us they don't want it. They don't even know about the cleanup bill and some of the exemptions. Some of these auditors, they're telling us.
A real business entity and not just a potential employee or potential contractor. But it struck me that was strange because doctors are largely carved out of employment law protections because of their, especially wage protections, because of their high wages. And so it's really hard. There's so much PR.
I just want to add that doctors, anybody is not carved out of AB5 due to how much their income is. Having a large amount of income does nothing to exempt you from AB5. Having a professional license, such as in healthcare, does nothing to exempt you from AB5.
Do you think that part of the conversation just kind of was based on the fact that she was just going hierarchy and going, look, the lawyers got to carve out. Look, the doctors did. So
she might be thinking that doctors did get a carve out from the Dynamics AB5, I mean ABC test, because it didn't apply to them because they're not wage order jobs. But they had to have an exemption from the ABC test of AB5 because all of a sudden it applied to them. So doctors have an exemption for a reason.
Sure.
Not because they make high wages. We've got tons of people in my group that are six-figure earners that lost their businesses because of AB5.
Yeah.
Hysteria that was in fact manufactured. That it was hard for me to.
Okay, wait a minute. Wait. I got to say something about that.
Really,
Manufactured hysteria. Steve, at some point we got to pull up my stories. I've got hundreds and hundreds of categories of professions in an archive of stories that I've collected for 4 years of people. Hysteria, manufactured hysteria. I don't think anybody reading any of the stories would think that any of it was manufactured or hysteria, which she just loves that word, hysteria.
So here's the list of what Karen's talking about. Is it coming up there?
Yep, I see it.
So, okay.
So if you scroll through there, you'll see all the categories. Let me put on my glasses. I mean, just read them out. Cancer registrars, chiropractors, chronically ill people, churches, comedians, commercial productions, community theater. Just
I mean,
and
it's
these,
ridiculous.
if you click on these little cells here, it brings up like, dozens of stories. Court reporters still don't have an exemption from AB5. I mean, there's so many stories within these archives that will just blow your mind.
And I'll share it with you guys too, so that you guys have it.
Here, pull up the pharmacist story. If you can scroll down to the pharmacist.
Mm-hmm.
Her story was outrageous. She actually lives up the street from me. She's a licensed pharmacist who has a doctorate degree and had a career as an independent contractor doing inspections of pharmacies and best practices and stuff all up and down the state. If you read that out loud, here, I'll read it. I'm a registered pharmacist, 8 years of college, doctorate degree, lost my contract to inspect pharmacies in California and around the country to ensure their compliance with standards of appropriate sterile and non-sterile compounding, security, cleanliness, personal training, proper policies and standards, and much more, all to ensure public safety for dispensing and consumption of prescription medications. Now the company for which I was contracted uses pharmacists from outside California to come here to perform the work I did. I invoiced and was paid monthly within the exceeding customarily hourly wages of pharmacists, $50 to $100 an hour. I was specifically told by one of Lorena Gonzalez's staffers that they only intended AB5 for low-wage workers and that professionals with 38-year professional career, professionals with a high barrier of entry to the profession should be excluded from AB5. See, they lied to her. They lied to all of us. Yet pharmacists are not excluded. Now, after 38-year professional career, I lost my ability to make a living and am now earning nothing. Explain that, Veena. Well, that's just one of hundreds of really, outrageous stories that came into my group.
What instances in which people were getting bad legal advice, instances in which people were actually being adversely affected, and in instances in which it was sort of just like made up. I think that of course, as
we can't even get like 10 seconds.
It's so insulting. I mean, it's appalling that she and Lorena Gonzalez, the author of the bill, are so dismissive of real life stories of loss and devastation and destruction and disruption and everything else. That we just making everything up.
Yeah.
And it's not just me and my group. Every single legislator was getting, calls when the law first went into effect or was first signed. When I called my assembly person, she said she was getting 100 calls a day from people in a complete panic. She told me she was a grant researcher on the side. The woman that answered the phone, the staff, the chief of staff. Grant writers are exempt, but grant researchers are not. So she lost her career. She told me she's gonna have to find something else to do to make a living, because she cannot be an independent contractor, and they're not going to hire her as an employee. The grant writer's not going to hire a grant researcher as an employee.
No. In almost every case, they're not going to hire anybody as an employee.
And just to let your listeners know how much insanity ensued at the beginning of AB5, every single band, a bar band, your local band that plays in a bar or restaurant or brewery or whatever, had to make their band members employees, and they couldn't do it.
Right, which I was just going to say, I've been in that industry, and there's no way that you could do that.
Yeah, so the musicians were very vocal. They put together like a petition of 700. They got 750,000 signatures on a change.org petition to get an exemption. And Lorena Gonzalez gave them an audience because they were amongst the loudest that were making her life miserable. But I mean, it was ridiculous. You could be a band member. You could have like your saxophone player sit in with you, and you'd have to make him an employee. And then you would sit in with his band one night, and he would have to make you. So you would be the employers of each other.
I know. I remember it was either you or Kim that I threw out the idea of, couldn't I just have like 50 different bands with different names, but have it be the same band?
Yeah, exactly.
Just call your band whatever the date is.
Another group that was really highly impacted was interpreters and translators. And the interpreters, they were so smart. They were really well educated. The group that was fighting for their exemption in any way they could, with their negotiations. And, they operate as independent contractors. And Lorena Gonzalez just had her heels dug in on them. She accused the industry of all this wage theft and stuff that turned out not to be true. And they eventually got an exemption, but they were making her life miserable too. These were not made up stories. They were actually lost work. They couldn't work. Sign language interpreters.
Yeah.
They couldn't work.
This is John Lopez. I'm not sure if you probably know John. He's in Chicago.
Hi, John.
So he's been making a couple comments in here. He's been asking about some other things too, but I'm trying to go back up a little bit because he's always in the chat sometimes for these Olson versus California federal case. I'm now going back in time a little bit here. In my role in local government, we needed to go with an independent contractor for administrative services. We're a startup, so it wouldn't have been possible to bring them in as W-2. I really hope AB5 will be brought up at Thursday's debate between Governor DeSantis and Governor Newsom. Check out Congressman Kevin Kiley's list of questions.
Joe, check out the op-ed I wrote yesterday in the California Globe about how AB5 should be #1 debate topic for Newsom, and how Newsom himself is violating AB5 with his freelancer photographer arrangement. It's all in my op-ed.
Newsom seems to break all his own rules.
He does, of course he does.
I mean, it seems pretty public though too. It's not as covert as some other.
I mean,
he's just right out in the openly, like, it doesn't apply to me. You might as well say that.
It's
the law doesn't apply to me.
Yeah. If he were treated like any other business, he would be subjected to, astronomical fines and penalties for misclassifying his freelance photographer, which he is, because I mean, there even though photographers have an exemption, within that exemption are 6 or 7 different requirements that you can't and one of them is that the photographer has to be able to set his own hours and not be controlled or directed as to where to work and when to work and all of that. So when he took his photographer with him to China, I mean, that is an employee relationship. That is not a freelancing relationship.
So Joe Beth here says that remember how Lorena Gonzalez saw a thick book filled with these AB5 nightmares and threw it into the trash without a glance.
Yes, that happened. Hi, Joe Beth. We had a letter. I wrote a letter signed by 8,000 freelancers for a motion to repeal AB5 that Kevin Kiley in the assembly was going to introduce to the assembly people in the legislature. And it was this big, thick packet of signatures. And when he handed it, he told me when he handed it to her, she cursed at him and tossed it across the desk and onto the floor. She didn't want to hear it, didn't want to see it.
So Joe Beth also said here, can only be a backup singer one night a week at a venue.
That's correct.
Is that still a thing?
Yes, the exemption. Musicians think they got an exemption, and all the headlines said, "Oh, musicians are all exempt," but they're not. It comes with restrictions, and one of the restrictions is that you can only perform at the venue no more than once a week. Yeah. So a lot of people, a lot of bands will play a Friday and a Saturday night consecutively, or they'll play a Friday and then they'll come back on Sunday afternoon. That's not allowed because it's more than once a week.
Yeah.
So tell me, how is that freedom for musicians when the government has that much control over?
Right. And honestly, why should they have to be an employee of the restaurant or the location?
It's absolutely outrageous. And you tell musicians, say, "Oh, we're all exempt." No, you're not. There's so many musicians that aren't. There's a segment of musicians that are not exempt at all. One of them being community theater.
Yeah.
The fact that there were eventually there was legislation, so clean up legislation, if you will, around the law suggests to me that there was more that needed to be done. But that's actually quite common when you have any big statute. There's going to be cleanup legislation.
Are you referring to AB2257?
Yeah, I believe that was the bill that sort of tried to assist.
That threw me to I believe that's AB2257.
It was
again, these are the things that I'm just mentioning it to you because these are the things that threw me a bit because I was like, there's no way I know this and you don't know this.
She must not be paying attention, or maybe she's just trying to be. I can't get into her head as to why she doesn't. She knows this though, right? Is she just not? That's confusing to me. Well, the fact that there was a cleanup bill suggests to her that there may have been some problems, but it's not unusual that big pieces of legislation have cleanup bills. No, AB5 was a scorched earth approach to policymaking where she just came in and she burned down the entire village and threw everybody overboard and then picked through the rubble and, for winners and losers as to who can be exempt and who cannot. And that is a problem. And AB 2257, even though it provided a few more exemptions and clarified a few of the existing exemptions in the law, it's still a convoluted mess. And there's all sorts of professions, hundreds and hundreds and hundreds of different kinds of professions that have fallen through the crack that aren't addressed by any of this, such as, and I've repeated this over and over again, freelance transcription profession is extinct in California. They do not have an exemption. I don't know why they wouldn't be in the professional services category of exemption. It's along with proofreaders and translators, but they're not. And so that was a profession that was dominated by females and seniors. And it's extinct in California. California is the only place in the entire world where a platform like Rev.com will not contract with you.
People who felt caught in the waves. But it's also important to note, I think, that for example, freelance journalists were amongst many of the people who some of whom were upset about this. But freelance journalism, the fact that so many journalists are not able to have things like health insurance, not able to have workers' compensation if they're injured, not able to have unemployment insurance, and are actually working primarily with one or two hiring entities, with one or two newspapers or media outlets, speaks to the reality that journalism has really disintegrated over the last 30 years. And it's created a lot of really
I have something to say about that. Journalism has disintegrated, but in a way that she may not be, meaning it. I mean,
Right.
this standard of journalism, I think, has disintegrated a lot. But in terms of, I mean, W-2 journal, having a W-2 job with in a newsroom is not job security at all. There are constant layoffs in newsrooms over and over and over again, and they come in cycles. There's just was a new cycle of layoffs in very prominent publications and magazines and newsrooms. And the only thing for me personally as a journalist that's protected me all these years and let me be the last man standing is the fact that I'm an independent contractor and I'm in business for myself. And because I'm in business for myself, I can deduct my expenses. So as far as healthcare is concerned, I have always paid for the highest possible, the best possible plan in Kaiser for healthcare because I can write it off. And workers' comp, you can. A business can include independent contractors in their workers' comp policy if they so choose.
A test in one state, but not all over the country, it's then easy for these huge media conglomerates to say, okay, well, we're not going to use you in California. If we have to treat you, if we have to give you, proper wages and protections, we're just going to go to someone in Arizona or go to someone in New Mexico. And that is an unfortunate sort of thing that employers do to lower labor costs. But it is, precarity. Journalism is in dire straits. I know a lot of freelance journalists who want jobs and deserve full-time jobs and actually are working for outlets where they're essentially a full-time worker but are being mistreated. And I think I would have hoped that this law would have really helped those folks too. But the reality of digital journalism is that people could, these sort of unsavory companies could just go elsewhere to find their work.
All right, Jo Beth can chime in here because she's the plaintiff with the American Society of Journalists and Authors lawsuit against AB5 in the state of California for discriminating against a journalist. And, journalists, if you're working full time for somebody, you don't need AB as an independent contractor. Yeah, you probably would be a misclassified person, under the terms of the Borello standard. But who are all of these? She says she knows so many journalists. I don't know a single freelance journalist, who thinks AB5 is a good idea.
No, and so this was from prior to you making that comment about Jo Beth, but she had said AB5's ban of self-employment for respiratory therapists and nurses who specialize in rape kits. Those were too heartbreaking. AB5 likely led to many deaths, but no one is counting them.
She's right. But Jo Beth is a freelance journalist, and she and I were invited panelists at the California Advisory Committee for the U.S. Commission on Civil Rights. They held these series of hearings about AB5 and the implication on minorities and disenfranchised groups. And Veena Dubal was also another invited panelist, but she refused to be on a panel with anybody. Jo Beth and I were on the March 8th panel, and she was supposed to be on the March 7th panel, but she worked a deal with the commission, and it's supposed to be public, right? That she would have her own special panel just for herself so that she could speak for a full hour. And they didn't even notify us that this was going to take place. And we found out about it an hour before it was supposed to happen. And we tuned in, and she was perpetrating the same narratives and tropes about hysteria and, all of these people. In fact, Jo Beth can attest to this. She said that all of us who are fighting the law, the freelancer movement, like myself, and we're just privileged white people who already are supported by our husbands or our spouses, and that freelancing is just a hobby for us. And the only reason that, we have time to even do any advocacy work is because, we have income from our spouses. She actually said that.
Yeah. If I remember right, her again, I don't remember the exact details of this, but I remember, isn't her husband or is that Lorena's? One of their husbands is with Amazon, right?
From what I understand, her
Or
Veena,
Lorena's was he's with Uber, but even
No.
Vena's was with. Am I getting this backwards?
well, I think Veena's husband is with Amazon, is a lawyer with Amazon, and Veena herself makes, according to Transparent California, she makes somewhere in the vicinity of $156,000 a year, you know, and yet her focus is on critical race theory. So if you look her up, she's a professor of critical race theory, and hasn't talked about that yet in this interview with you, but she wrote a paper called The New Racial Wage Code, and she equates Prop 22 with the racial inequities and injustices and subjugation of the New Deal and the plantations in the South and the cotton mills and everything else. And the Prop 22 is written specifically targeting and discriminating against minorities and people of color. She wrote that. And I read her paper. I did. But what she failed to mention in her paper is that the people who wrote Prop 22 were Tony West, who's the chief legal officer for Uber. He's Black. He's Kamala Harris's brother-in-law. Anthony Fox was the Obama's transportation secretary, and he's the chief policy officer for Lyft. Valerie Jarrett, who was the Obama's chief of staff at the White House for 8 years, is the director of the board of directors of Lyft. And LaFonza Butler, who is now our new state senator in California, Newsom appointed her. She used to be with SEIU, but she in 2019 she went to work for Uber to help them craft Prop 22. So Prop 22 behind the scenes was LaFonza Butler is Black as well. So, but Veena Dubal doesn't put that into her equation. But I will give Veena Dubal some credit here. When Newsom appointed LaFonza Butler to that seat, she was the only person prominent in the labor movement that called BS on it and said she was a turncoat to SEIU when she went to work for Uber to do Prop 22. Even Lorena Gonzalez herself had a meek sort of congratulatory response and didn't speak out about that. So at least Veena had the balls to call out that hypocrisy.
Right.
And I read that in the Times. She was quoted in the Times.
I see what you're saying there. I'm curious because some of the people I know were even like S corps and things of that nature. But again, who knows what each of the situations is. I've talked to them, and I know that in some ways or another, it just affected a lot of people. But I also know that musicians weren't carved out, and then they were, and then interpreters weren't, but then they were. So I know it took some time. I thought that was part of AB 2257. But getting back to Prop 22, when that was voted on in November. I know that if I was reading the quote right from TechCrunch, that a ballot initiative cannot be amended after it is passed by voters. Any unconstitutional provisions renders it unenforceable, which is the reason why Prop 22 got overturned by Judge Frank Roche, correct?
Yeah. So he he found two parts of Prop 22 to be unconstitutional, and one of those parts of Prop 22 that he found to be unconstitutional was the center of Prop 22. So they couldn't just excise that portion of the proposition; it excised the entire proposition, which is why the entire proposition was found to be unconstitutional. And it was the portion of the proposition, the part of the law that said that workers are carved out of all parts of the labor code and the unemployment insurance code. And the reason that he found that.
She just said workers were carved out.
Right.
No. Prop 22 was only about rideshare and app-based delivery drivers, not all workers. So I'm sure she misspoke and she didn't mean to be duplicitous with you. But when she said workers, Prop 22 Prop 22 is a very narrowly applies to only one industry.
And I was gonna say to add on to that, I've had people ask me, well, what about those companies like Curry, last mile delivery, that's still an app? but they're like, you know, those are held to Prop 22 too. And I'm like, no, they're not. I'm like, there's smaller companies that don't fall into that, or they're not paying into it, and they're meeting the legal requirements. I know these companies.
Wow, I didn't know that.
So it's like there must be some threshold on some, whatever the size of your platform app is in California or something. I don't know, because they definitely are not paying into Prop 22.
I don't know.
So
be unconstitutional is because in California, the workers' compensation scheme, the legislature's plenary power to create a workers' compensation scheme is actually embodied in the California Constitution. And what Prop 22 did was to say, legislature, you cannot provide any kind of workers' compensation scheme to workers.
No. Again, she's over workers and says that it said the legislature is not allowed to provide workers' compensation schemes or systems or whatever. That's not what Prop 22 said. Prop 22 said that the voters could participate and be part of that plenary power, that the voters are afforded that plenary power of being able to make that decision about workers' comp.
Essentially forbids it, and he said that actually flew in the face of the plenary power of the legislature to do so, to create a scheme of protections for workers who do dangerous work. And it's interesting to note that was put into the Constitution.
I'm sorry.
Just so you guys are all aware, whenever Karen puts her finger up, was there our cue for when I'd pause. So
dangerous work. Let's talk about dangerous work. AB5 app-based delivery companies and Uber and Lyft and all of them are excluded from a carve out in AB5, prior to Prop 22, because they're quote unquote dangerous, hazardous occupations. But if you look at AB5, one of the most hazardous occupations in the entire nation, the second most hazardous occupation, is commercial fishing. And commercial fishermen got an exemption from AB5. Timber logging is a very hazardous occupation. Foresters got an exemption from AB5. Construction truckers got an exemption from AB5 for some reason. It must have been some union thing. And construction subcontractors got an exemption from AB5, or from the ABC test of AB5. And then in the referral agency category of exemptions, which Uber and Lyft feel that they should belong in, there are occupations under like a TaskRabbit agency that also are exempted, including moving furniture and errands. So I'm looking at it, I'm going, Steve, if errands are exempt from AB5, don't you use a car to go on an errand for somebody who hires you? And maybe like an errand runner would be somebody that would go to the grocery store for the senior and pick up groceries and bring them back. What? How does any of that make sense?
I don't think any of it makes sense. I thought that's why we're here.
Moving furniture, you can be crippled for life moving furniture, yet they have an exemption. Yard work, people who trim I mean, come on. Yeah. So don't tell me.
I don't know if you know this, but now rideshare is listed or gig work is listed in the top 10 most dangerous professions in the nation.
Yep.
So,
yep. But it's okay to be an errand runner.
Yep.
It's okay. The most dangerous profession is logging, followed by fishing. Commercial fishermen have an exemption. Why?
I don't know, because they need commercial fishermen, and they wouldn't do it under any other way.
I don't know.
And so therefore they need. I mean, it's like a forced need. They won't do it if they have to be employees.
Those exemptions, belie the fact that this law was designed and written to protect workers.
Yeah.
In the late 1900s, early I'm sorry, late 1800s, early 1900s, particularly because we were living in, they were living in the Gilded Age, where you had these deep-pocketed companies who had a lot of personal connections to lawmakers, and there was concern that they would try to get out from underneath the workers' compensation scheme or try and change the law so that they didn't have to provide any kinds of workers' compensation coverage for their workers. And in particular, there was concern around the deaths and injuries in transportation work, because cars were starting to become more common and used for work purposes, and accidents went through the roof, and there were so many more occupational injuries than there had ever been before. So this was, to create a safety net for people who were injured on the job in those circumstances. And I think that's relevant from a policy standpoint, because, of course, as you and your listeners know, this is very dangerous work. OSHA says it's one of the most dangerous jobs in the country, not just as a result of people getting held up, but also because of accidents and injuries that come with being in the car all the time, repetitive injuries that come with being in the car all the time. And so I think this is the type of work that workers' compensation laws were created for.
The other part of what Judge Roche, I hope I'm saying that name right.
Yeah, that's right.
Okay. The other part of what Judge Roche was talking about too was the right to organize, though, as well, right?
Yes. So Proposition 22, this actually didn't make the whole thing unconstitutional. I believe that this part could have been excised from the proposition. But interestingly, they were really trying to have their cake and eat it too. They just threw in a section in there that says, the state can't create a way for these workers to organize, and or can't pass a law to allow these workers to organize. And what the court said is that this part of the decision, or this part of the proposition, violated what's known as a single subject rule, and that is for initiatives like this, the initiatives should only cover a single subject. And what this proposition claimed to do was to make, ensure that these workers could be independent contractors and to extend some new benefits to those workers. Nowhere in that statement did it say anything about, preventing them from organizing. And so the fact that they just sort of threw that in there, the court said, Judge Roche said, violated the single subject rule. It was about something completely different than what the proposition claimed to be about. And so for that reason too, that portion of the proposition ran counter to the California Constitution.
Do you have a question about all of that?
Mm-hmm.
Judge Roche, when he ruled Prop 22 unconstitutional back in 2021, I think it was,
Mm-hmm.
the California Alliance of Business, California Business and Professional Alliance, CABIA, Business and Industrial Alliance, released an article listing all of the bad rulings that had been overturned by this same judge, a Superior Court judge in Alameda County, and including being reprimanded for bias. He's had a lot of rulings overturned. So in my view, in Berkeley, he may have been an activist judge, but Prop 22 was found constitutional back in March of this year. They it went to a court of appeals, and they found that it's kind of hard to explain, but they found that the legislature and the voters can make workers' compensation law. Here, I'll read it exactly. First, the proposition did not intrude on the legislature's workers' compensation authority, because while the legislature has plenary power, this power was not exclusive, as references to the legislature's powers and are interpreted to include the people's reserved right to use the initiative power. Secondly, the proposition did not violate the single subject rule simply when it embraced multiple purposes, because propositions may properly accomplish comprehensive, broad-based reform. So those two main components or provisions of Prop 22 were upheld as constitutional. And then that part about not allowing the legislature to amend Prop 22 for the purposes of making laws so that they could collectively bargain, that was severed from the proposition. So anyways, it required a 7/8 majority of the legislature to amend the proposition. So that
Well, I was also kind of
unconstitutional.
I was trying to get at how you're going to get everybody to swallow this pill anyway. You already had them vote on it.
Right. And the state of California is the one that has to defend Prop 22 in the court. So SEIU is taking this to the California, back to the California Supreme Court, because Judge Roche's ruling was overturned by the Court of Appeal this March. And then SEIU filed they want a review from the California Supreme Court, and the California Supreme Court now is agreeing to hear them out on this. So we'll see where it lands. But the person that's going to be defending Prop 22 before the California Supreme Court is the Attorney General of the state of California, because he is obliged to uphold the will of the voters.
That's what I was just going to, it seems like crazy to me, because they're going to have to defend it. You can't go back and tell all these voters like, oh, sorry, we didn't look at the law first.
Right. But then again, back in 2018, it was the California Supreme Court that came up with the ABC test. Yeah. So, I mean, we would want to hold our breaths, I think, and we don't know how it's going to turn out, and we don't know when it's going to be heard. But, we'll see. But the long and short of it is that Prop 22 was upheld to be mostly constitutional.
I'm not even sure you'll know the answer to this, but how does a proposition like this get presented and it not get flagged that, hey, this isn't in accordance with California Constitution?
Yeah, so the California Attorney General did approve of the proposition. And that's why it was allowed to go on the ballot. They approved of it as constitutional. But there's always review. There's always judicial review of these of propositions. And in this case, the judge is saying, look, California, and at this point, it is the California Attorney General that is defending this case, right? It is now the law, or it is the law in California. The law passed, and so the Attorney General has to defend it against the plaintiffs. And so the plaintiffs are alleging, actually, there are parts of this law that are unconstitutional, that the California Attorney General should never have allowed to exist. And looking at those allegations, the judge is saying, yeah, you're right. Like the AG's office made a mistake. There are things here that are unconstitutional. But you can't bring a suit like this until it becomes law. Like once the AG's office says, gives, rubber stamps it and says, sure, it can go on the ballot as a referendum, then you can't actually challenge its constitutionality unless it is passed, which is why we're having this litigation at this late date after the passage of the law.
Yeah, I'm just shocked that all these lawyers' eyes who were on this document didn't see it, or else they did, and they said, and that's the part I guess I'm a little confused on is, obviously somebody had to see this, that this isn't going to the Constitution. I think a couple of things. One, I think that these issues, the single subject issue, I'm sort of more surprised by, because that just seemed very obvious to me at the outset. But the workers' compensation issue, interfering with the legislature's plenary power to put forth a workers' compensation scheme, this is an issue of first impression. The courts have not seen this. No one has ever tried to do this before. And so it's not immediately apparent to me that whatever lawyer, the AG's office that was reviewing this, that they would necessarily see this and think, oh, this is necessarily a problem. And so, these are government lawyers. They're short-staffed, under-resourced.
That's kind of insulting. She just insulted all the government lawyers and the Attorney General, telling them they don't know what they're looking at.
I guess I'm still baffled, because I'm wondering, like, I saw you agreeing too that is how it would play out, but I don't get why something needs to be voted into law before the lawyers could say, wait, this isn't constitutional.
Well, it has to.
I don't see why both sides,
right.
if somebody's going to protest that it's unconstitutional, shouldn't it not be voted on?
Well, that when it was put on the ballot, it passed the muster of the Attorney General, who, by the way, rewrote the summary of it to make it, kind of twist the verbiage around, saying this Prop 22 is about rideshare drivers not wanting to provide their people with benefits. When in reality, Prop 22 at its core was about allowing rideshare and delivery drivers to remain independent contractors.
Right.
First, they might not catch every single legal issue, especially when those legal issues are new. And I think in this instance, there's probably just, practically speaking, a lot of deference to the company's attorneys. There's a sense that these companies are able to hire the very best and the very brightest, and they know what they're doing, and that they are owed some sort of deference in their interpretation.
Okay. Yeah, I mean, I know this gets really hairy and messy, so here's a question that I would actually kick myself if I didn't address today.
Sure.
Which is, and it'll play into flex a little bit too. But so, is there a way, a path, something that you see where people can choose to be employee or independent contractor? And I say this because, like in my case, I prefer to be an independent contractor because I do a variety of jobs. I work for a laser company. I sometimes do freelance social media. I run my website and podcast. I work SaaS platforms like we've talked about. So for me, it's such a jumbled mess. And if I'm in working production, I could be gone for 7 weeks, 8 weeks.
Totally. Yeah.
Come back and I need work for 5, 6 weeks.
I hear you. So I think there are two really important things to understand here. And that is that people really need and like this work for two primary reasons. One, because of the kinds of flexible scheduling that you just articulated. I know a lot of people who live transnational lives, and they will work really hard for 6 months, make some money, and then go home and live with their family, their wife and kids for another 6 months in South Asia or the Middle East, and then come back and do the same thing. And it's their lifestyle. It's what they've sort of embraced, and it's what they want to be able to do. And this enables that. The other thing is that no one wants a boss. I don't want a boss. You don't want a boss. No one wants a boss. In America, employment law is rooted in the English common law of the master-servant relationship. Employees have very little power on the job. There is so much deference to employers and what they're allowed to do to people, what they're allowed to say to people, how they're allowed to treat people. And I think there's some sense, and I think this is probably accurate. There's a sense that, these companies, if they pretend like their workforce is an independent contractor workforce, then they are prohibited from doing certain things. Like they're not going to tell you to wear a uniform. What I hear from workers that I organize with is that what pisses them off is that they want to be contractors, but that they're treated like employees. And this is true across the board, right? Like this is true for all misclassified workers. When you talk to those FedEx workers, when you talk to the misclassified nail salon workers, these are people who say, look, I want to not be controlled by a boss, but they set my wages. They drop my wages. They punish me if I don't do the things that they need for me to do. And they can terminate me at any time. And I can't actually negotiate these terms with them in any meaningful way. Like I'm not actually being treated like a true small business person. And so then the question from a policy standpoint becomes,
she didn't really answer your question because I'm surprised she didn't use the word you cobble a bunch of jobs together. And we don't like that cobbling, she didn't really answer your question. You like what you do. It's not because,
in fact, she seemed on board with it.
Yeah. Nobody likes
which again kind of went against most of what I think she says.
Yeah, I don't know.
I was just telling her my scenario, and I feel like she was like endorsing it almost. Yeah, I get that.
In the minds of these, labor proponents like Veena Dubal and Lorena Gonzalez, you should have one job that pays you a living wage, and you shouldn't be forced to have to cobble together jobs. But as business people, cobbling is a derogatory term. Cobbling is actually a client roster for me, Yeah,
I was going to say I don't look at it that I'm unfortunate and to have to cobble things together though.
They usually.
I view it as I chose that and I like that.
Well, she was probably just being polite, but usually she and Lorena Gonzalez will use the word cobbling. We don't want people to be so destitute that they have to cobble all these jobs together. When you look at the statistics, a lot of people, a majority of the people that do gig work, they already either have a full-time job or a part-time job or are covered by their spouse's insurance or have their spouse's health insurance, and they do it on the side just for fun or to make some extra cash, on the weekend or whatever to pay for their kids' little league. So, she's looking at it through the lens of a full-time job, and she's discounting, the way that most people, approach gig work is that, it's just a side hustle, something to make some extra cash, turn on the app once in a while and go out there.
Mm-hmm.
You preserve flexibility while also creating security. And I think that what we have to remember here is that what's on the line is not just ride-hail work, not just food delivery work, but really all service work. Because if we can, all corporations want to lower their labor overhead. Everyone does. Since the 1970s, this idea of having a worker that was loyal, that stayed with you, and who got a gold watch at the end of their 40-year tenure, alongside their good pension, this is just gone. And HR sees workers, they see employees, they see them as a necessary overhead that they want to minimize. And so companies like Google will do this by hiring through staffing agencies. Google has more workers that they hire through staffing agencies than they do have full-time employees. And companies like Uber and Lyft will use contractor labor as opposed to employees, so that they don't have to deal with the additional 33% overhead that they would have to pay into unemployment insurance, that they would have to pay in workers' compensation, et cetera. But there's nothing actually about, you can be an employee and for workers' compensation purposes, but not be an employee for wage purposes. So there's not, the law is not written in such a way as you're either an employee or you're an independent contractor. The law was really written as when it was written in the 1930s during the New Deal, as a way that all subordinated workers, people who worked with or for corporations, had the ability to have some semblance of security in their lives. So the idea was, you should be able to, if you work for 40 hours a week, you should be able to predict how much you're going to make during those 40 hours a week to protect your family. If you work in a dangerous job, you should have some protection. Instead of paying for these things through taxes that were imposed more broadly, they pay for them specifically through employer taxes. And so because you pay for Social Security, workers' compensation, unemployment insurance through employer taxes, it incentivizes hiring entities to say, well, we don't have an employer. We don't employ anyone. We're not employees. And so that leaves me with these two issues. On the one hand, you have a workforce that clearly needs security. We know that 1/5 of workers in the Bay Area prior to Prop 22, this was a study that was done prior to Prop 22, after you accounted for their expenses, they were making zero money. So this is a precarious workforce that needs some security. On the other hand, these are people who also need flexibility and that cannot work 9 to 5 jobs. So how do you get both of these things? I think that one of the amazing things that technology makes possible is flexibility. You actually could have, if the companies wanted you to, you could have the same flexibility that you have today and have workers' compensation and have unemployment insurance. It's that they want to hold that gun to your head to say, look, if we have to give you workers' compensation, if we have to give you unemployment insurance, then we'll take away all of your flexibility. It's not clear to me that they would take away that.
They've come up with this new line of defense about using flexibility as that's the end all be all to why we want to be independent contractors. And they think, well, especially since the pandemic, a lot of companies are offering what they say is flexibility. You can work from home now or remotely or whatever. But being an independent contractor isn't just about, and being your own boss isn't just about flexibility. It's about, charging your own rates, picking and choosing your own clients, not being beholden to a single boss or an employer, being able to deduct your expenses. And some careers and professions, that is very, very important. When you're an employee, you can't do that. As a writer, you're able to, as an independent contractor, retain your intellectual property rights, which is, something that you write doesn't, you can republish or resell or whatever. But if you're an employee, you can't. And also just the opportunity that independent contracting brings to give you a leg up in the profession of your choice and be able to try new things, like with the opera companies, for example. The mid-tier opera companies are training grounds and for young singers to be able to work their way up the ladder. And so independent contracting does it for me, if I were just stuck in one lane in a job, we wouldn't have had the opportunities that have been afforded to me as an independent contractor, being able to do all of these variety of different skill sets that I've added as to my resume as a creative professional.
Yeah. I'll play a little catch up here with chat. So John Lopez says that here in Illinois, the National Writers Union pushed bill freelancer worker protection law was signed by Governor Pritzker and takes effect July 1st of next year. Joe Beth says that Veena said we are all white women married to wealthy men. I don't know anyone in our nationwide coalition who fits that description. In California, our coalition against AB5 is extremely diverse. She also said that Veena dismissed every person of color in our coalition, including dozens of women of color who testified in public to the U.S. Civil Rights Commission. And she finally said that exemptions were handed out to well-funded groups, pay to play.
Yep, all of that. And Joe, I don't know what's the details of that law in Illinois, but it's happening in other states, in Minnesota and Michigan. I spoke at a task force in Minnesota because they're considering the ABC test. You don't want to see the ABC test from California spreading to other states because of the chaos, and they all know that it's been a disaster in California, but yet they still want to ram it through in some places.
Yeah, I don't see how you could look at this whole thing. You've had enough time to look at it now. If you're another state and go, this didn't work.
Yes.
I mean, like it's, I don't know, man. I don't know how it's not that clear to other people.
I don't know. It's just, they're clinging to the past almost. It's anachronistic. That the new wave of working is here, right, with on-demand gig platforms and all the rest. And there's got to be some kind of, as flawed as Prop 22 might be with its benefits and protections purported, at least it kind of paves a way or jumpstarts an idea that there could be a third kind of hybrid classification for workers.
Yeah, I think that was a big problem. I've always said I think that's a big problem that around the app-based gig economy anyway, is that there was no definition made as to what it is and how it works before now the laws are coming into place, and there's still no definition for it. It was never a traditional gig economy job. Like, I think there are some challenges that I can skirt around and things like this. So
I can totally understand the people who hate Prop 22 and think it's outrageous that these companies got to carve out their own, basically write their own labor law that exempts them not only from the ABC test of AB5, but also the traditional Borello test, which everybody else is held to. If I have an exemption that exempts me from the ABC test of AB5, I'm still held to the Borello standard. Everybody is, including doctors and lawyers, but Rideshare isn't. So I can understand why that would rub people the wrong way. But by the same token, I wasn't about to vote no on Prop 22 because I'm freelancers against AB5, and a vote for no on Prop 22 meant that you were endorsing AB5 as a law that should be enforced, and that 75 to 80% of drivers wanted to remain independent contractors. And that was the bottom line with Prop 22 was the independent contractor issue.
Yeah, Joe Beth kind of hit on something that stuck with me here, that Veena knows about these app drivers only drive a few hours. I can say that we know that nationwide, 85% of the gig economy, of the app-based gig economy, works 20 hours or less a week. And we know that 65% works under 10 hours a week. So, I mean, only 15% is full-time. So we're dealing with such a small percentage that if she knew that, she would know that this wasn't going to provide much benefit. You and I were talking about this in the beginning for to get the insurance and things like that. Like, you have to meet a lot of requirements that most of them won't meet.
Right. It's about engaged hours and all the rest. So, but by the same token, every other profession that got exemptions or carve outs from AB5, we don't get benefits and stipends and protections carved into our exemption. You know, I see that those purported perks that they threw into Prop 22 as kind of like cheap stocking stuffers wrapped in a shiny bow, you know. But the real present under the tree is the fact that you can remain an independent contractor.
Yeah.
Because
I mean,
then
that's-
what do you want? What do you want? What's the alternative? You want to be an employee driver? Be careful what you wish for.
Yeah, no, I've said this many times. You know, not only do you not want that, even the people who think they want that, I never understood, because just go out and get a W-2 if that's the case.
Right.
I mean,
So
there's
it's a
W-2s to
conundrum.
be had for good pay, decent pay. So I mean, if you just want a W-2, go get one, because don't drop a grenade in it for everybody else.
Yeah, but Veena Dubal equates it through the lens of racism. Here I have a quote from her. Prop 22 of the gig economy takes the racist ideologies from the early part of the 20th century and reinscribes them into law and grows them so that the most vulnerable people of color in the workforce do not have the ability to predict their income. So from her viewpoint, she has this extreme viewpoint that the failures of Prop 22 or whatever, or this rideshare model, is really because, you know, it's all about white supremacy and racial injustice in the end, and it's deliberate.
Flexibility, because then I think they wouldn't have a workforce. But how do you create flexibility? And I think there are two ways to do that. Two ways to create flexibility alongside security, and that is we could legislate for flexibility. We could say, look, no matter what, if you are working for an app-based company, you can log on anytime and work anytime within some sort of reasonable boundaries. And that would sort of prevent them from saying, you know, look, Steve, if you haven't worked for 6 weeks, you can't work after that. But I think that another way to get there, and this is something that we've seen for much of the 20th century, is through union contracts. You know, when you have a union that is a collective bargaining unit that is bargaining on behalf of a workforce, they can bargain for things like flexibility. And in fact, I saw that in my studies of the taxi industry for most of the 20th century, from like 1909 to the late 1970s. The taxi workforce was flexible in the same way that you and I understand flexibility. There were many people, again, who lived transnational lives, particularly in the 60s and 70s, who came and went. There was a lot of like sitting around drinking coffee, eating sandwiches, people working when they needed to, and that was all part of the way the union was able to structure. And you know, that's not to say that was a perfect time, or that those are perfect. You know, there are other things wrong, I think, with the tax industry, which I write about in some great length. But again, like, it is possible. It is possible to have security, and it is possible to have flexibility. And I think that the fact that the narrative is one or the other is part of, it's an employer narrative. It's the narrative of the company that wants to give as little to their workers as possible, and to take as much as possible. You know, there are some companies in San Francisco as a result of AB5 who are on-demand companies. I have a colleague who writes about this, Juliet Shore, you should look at her work. They're on-demand companies that actually move to an employee model, and they say two things. They say, and still have flexibility.
Steve, are you aware of any companies in San Francisco that are W-2 on-demand models? Because
in fact, I'm pretty sure that I'm familiar with all of them, and there's not.
Because you had Sprig, you had Ship, you had Lux Valet, and you had Eden, and they all went belly up. They tried to be.
Shipped is still around. That's Target.
Yeah, but I mean, it was like Sprig was in San Francisco, and they had like $57 million in funding, and they tried to do that employee model like she's asking for, and it didn't last for more than a year before they closed up shop. So I'm not sure which ones, what she's talking about.
Yeah, I mean, when you said, you just mentioned Shipped anyway. I would also point out Amazon Flex. Amazon's one of the largest businesses on the planet, and Flex is allowed too.
Yeah.
So, I mean,
and you know, here's another thing about Uber and Lyft and rideshare. Do you know that in California, there's 300 school districts that contract with these on-demand companies to drive special needs and foster children and that to back and forth to schools. And then when Prop 22, before it even went into effect, the federal government, I think they brokered a contract of $800 million with Uber and Lyft to drive, people, federal workers around DC.
Mm-hmm.
So they talk. It's like you got one side and the other side, but they're all kind of, contradicting each other.
Yeah.
They say two things. One are it's actually been better for them because they don't have such churn or turnover. Like they have the same workforce that they like and that is sort of professionalized and knows what they're doing. And the workers say great, like I have the best of both worlds. I have flexibility and I have the ability to predict at the end of the day how much I'm going to make, and I'm not worried about a rate cut in 2 weeks time. And so yeah, I mean this can all be engineered. There's no way that there's no world in which this has to be work that is unpredictable and unprotected and inflexible. It can be any combination of flexible, predictable. I mean, it can be all of these things. It's just a matter of resituating where they invest their money. Instead of giving the CEO $1 billion, instead of paying lawyers billions of dollars to fight these lawsuits, instead of paying lobbyists billions of dollars to change the law, they could reallocate this money and provide flexibility to their workforce simultaneously. They just don't want to.
I don't see how that is just pie in the sky thinking.
That when it comes down to flexibility, it's we know it's not a law that a company can't let you have flex work. It's that no company does. Well, I mean, companies, this is what I was just saying, is that companies have been doing this since AB5 passed in California. And I just mean the actual, what we're used to is the gig model of being able to jump on. That is precisely what's happening. I mean, right. You of course have to limit. They would have to move to some kind of limiting. And well, what they did was they limited, they just say we have X number of people and these are the people that are going to, have flexible schedules to work. And it's not like everyone in the world who wants to sign up for Uber.
Just so you know, I have no idea what she's talking about. I have no idea who she's talking about. This doesn't exist.
I know. I mean, and you would know, and I could tell by the tone of your voice that you were very dubious about what she was saying. And also, it's just not possible.
But she's saying that it is. Not only is it possible, she was saying that it's happening right now. I was like, what? I'm like, there's no business in the planet that just lets you clock in when you want.
Yeah, if you were paid by the hour as a worker, you would be. I mean, as a gig driver, yeah. How does that prevent somebody from just sitting in bed all day with the app turned on?
Right. Well, I mean, the way that they did it, even California's Prop 22, you're only paid for the active time.
Right.
You're not paid for having the app on and sitting at home.
But that's not what she doesn't like that, according to what she's saying.
Well, according to her, you can have your cake and eat it too.
How can I as a freelance writer charge my own rates per project and everything else like that, like I'm used to doing and I've always done? If I'm a W-2 employee, no matter how much quote unquote flexibility she thinks I can be granted, what does that look like? It doesn't. You're on a salary or hourly. If you charge by the hour, you have to. I mean, it doesn't make sense how a business person like myself and like all these other hundreds of categories of professions can just automatically become, W-2 employees and have flexibility. If you want flexibility, be your own boss.
Yeah.
Sign up for Uber, but that's of course what you want in any labor market. You don't want unbridled supply of workers when demand is so low. Otherwise, you get a situation like we have here in California in the Bay Area where people are driving 16 hours and not able to make a living because there's so many people all of a sudden driving now that their unemployment insurance has run out. So of course that's good business it's good business, good for the workers to say yes, we want a finite number of people who do this job. We don't want, everyone in the world doing the job, but but those workers who are doing it can have flexibility, and there can be two tiers of workers. There can be part-time workers and full-time workers, and part-time workers can work during periods of high demand, and full-time workers can work whenever. I mean, there's so many ways.
You know, I got to say at this point that now time is showing a different story, because with the illegals that are in the country right now, a lot of them are working these jobs because you can buy accounts on the black market. You can go to the dark web and buy an account. You can rent them per day from people, so that you're using their account, and then you can cycle it and run it 24 hours a day and have 3 different people working at 8-hour shifts.
Yeah, that's a problem.
So now you've got people who haven't been background checked being put into positions where people could be in jeopardy or whatever, and it's not the correct person doing the work.
Yeah, the ride-hailing business model is always going to have, you know, problems, it seems to me.
Yeah. I mean, the you know, Sergio had said a very easy solution, and I know the technology didn't used to be there, but he's right. Like it would be a good start because it's happening more on delivery platforms than rideshare, where a lot of these accounts are being rented. But he said, just have it every 2. He's like, I'm an immigrant, so I'm not being a jerk here. He's like, just have every 2 hours. They have facial recognition.
There you go.
Hey, make sure it's you.
That's the industry solving the problem within itself, you know. They
Right,
see a problem.
but by letting it be triple oversaturated, it's to their advantage, because now they can lowball the offers.
Right.
And people will still take them, where when it's just normal oversaturated, people will pick and choose what's best for them. But it's become it's again a race to the bottom, which is a thing we used to say, and now we don't say it as much, but it's becoming a race to the bottom again.
Yeah, but every driver, gig worker is caught in that race to the bottom. It's not just the people that are immigrants and people of color.
Right, but one of Sergio's points that stuck with me is he's like, you know, the people that come over from other countries that have got into here, he's like, you know, to you, I'm like, but I know people, you know, there's people who are renting accounts out who all they do is have it in their name, and they rent it for $100 a day or 120 a day. What if the person can only make 200? He goes, that's still $75. Do you know in their country they'd only make 10?
Right. Well, the solution really is to close the border or secure the border.
Right.
You know,
but I'm saying that has become a big infiltration.
Going over the border are going to take on these, you know, and they're going to bring down the going rate for everyone else.
Yeah. But because it's so easy to get into this, that's become a huge outlet for them to make money. And it's hurting all the people who really, really hustle this and do it right.
Wow.
Do this. And the trade-off here is that a majority racial minority and immigrant work.
Oh, my point to that anyway, too, was that I wonder where her viewpoint is now with the illegals that have jobs because of this.
She probably thinks they're being exploited and racially subjugated, and that they're, you know, I mean, it's no different than you know, what she calls the new racial wage code. You know, like at the New Deal, she talks about the New Deal and how it discriminated against Black Americans in terms of minimum wage.
Mm-hmm.
You know, she thinks it's the same. She says it's the same type of thing going on with Prop 22 and rideshare industry.
These are people, for the most part, the people that are doing the work. As you know, most of the work are people who are working more than 30 hours a week, and these are people who need. These are people for whom minimum wage laws were written, for whom unemployment insurance laws were written, for whom workers' compensation laws were written, and they need these basic protections. I also hear very, very, very clearly that they want and need flexibility, and I've been talking for a while to legislators about how they need to move to facilitate this, just as they have moved to provide basic protections.
Yeah, I mean, because I know, I mean, just almost every driver I talk to.
I heard her say 2 things. She talks a lot to legislators, and she also organizes.
Mm-hmm.
So is she actually a Rideshare Drivers United organizer misclassified as a law professor?
Well, she does have a law degree.
Yes.
I'm guessing. I mean, I actually don't have proof of it, but
Well, if you read her new racial wage code, which I read before, I reread it actually before this today. She makes it sound like she's just studying these people, and she has nothing to do with any behind the scenes organizing at all. And she actually quotes Nicole Moore. You know who she is? She's a white woman who actually makes well over $111,000 a year with the county of Los Angeles, who claims to be this poor, impoverished, Lyft driver. And she's actually, she's the organizer. She's the go-to person that they interview, and she and Veena Dubal organize together.
Mm-hmm.
They do, they do.
Oh yeah, yeah.
Excuse me. And again, it's market to market. I mean, I talk to so many markets where people are doing great. I talk to so many markets that are so flooded that you can't make a dime.
Yeah.
So it really is.
And that is precisely like that is always going to be the case without regulation. And what will happen, of course, is it might be one market that's flush with cash right now or flush with demand, and then that will rapidly shift for various reasons. And those rapid shifts end up hurting the people who are producing the value for the company. It's not going to hurt the engineer or the PR guy or the government relations executive. It's going to hurt the driver who's not going to have anything to fall back on.
Okay. So I have one last question for you today, Veena, and
Sure.
I'm going to touch it for you, and I really appreciate your time. But so moving aside from California and AB5, because right now I feel like, I also get, I get so upset with both ways of looking at this often, because the companies, even who wrote Prop 22, clearly there's been some issues with them following Prop 22 that they wrote themselves. Mm-hmm. And I know that. So I mean, the state that it's in right now, I understand that it's going to now come to California having to decide about the AB5 thing. And without getting into PROACT, because I think that's a little too much for today, I wanted to at least ask you about Massachusetts Bill H1234.
Yeah.
And I wanted to ask you about this because it appears like in the beginning when I was first watching this, it appeared to be modeling AB5, but now it seems to be trying to do some things in a different way, like is it the Coalition to Protect Workers?
Yeah, HR 1234 is a Prop 22 copycat law. So it has the same things that Prop 22 has, which is to make all the workers independent contractors, and
so this law is trying to be passed before an AB5 type law. They're trying to pass the Prop 22 type first.
Yes, yeah. So they're doing two things. They have introduced this House bill that's very much like Prop 22. They've also introduced an initiative. It's very strategic. So they've introduced an initiative which would also be just like Prop 22 and is just like Prop 22, but would be, not all states have an initiative system, have a direct democracy system, but Massachusetts does, just like California. And so they have introduced both things. The initiative would not be voted on until 2022, so the next year. And what they're trying to do, I think, is to spur enough. I think that they know that they likely wouldn't be able to pass such an initiative in Massachusetts because of the bad reputation that Prop 22 has after it got passed in California. There's a lot of regret in California, even by people who voted in favor of the law, given what we've seen and the amount of misinformation that went into passing the law. And so I think that what they're trying to do is to create some sort of compromise at the legislative level. So it's like a game of it's like they're starting at the bottom with this HR 1234 or whatever the number is, and then trying to see if they can get stakeholders, unions, drivers groups to bargain with them over something that's maybe a little better than Prop 22, but not quite employment status.
I mean, because I see this as, now that you're stating it like that, I see this as if they're doing. First of all, I really don't understand why they're. I would guess that it's because there's legislation coming.
Well, no, they're doing this because Attorney General Maura Healey has sued them. They already have the ABC test in Massachusetts. They've had it for years, since the 90s. And so the Attorney General of the state has sued them to comply with the law. And so they're in the same situation that we were in, in 2020 and early 2020. And so they're trying to, before that lawsuit is decided and there's an injunction against them, they're trying to get a law passed that will relieve them of these duties.
And you're talking about the time when AB5 was passed until the time that
Prop 22 passed.
Until the Prop 22 vote.
Yeah, that's right, exactly. So that's what's going on in Massachusetts. But we know it's interesting. I mean, we have a roadmap for what they do.
Well, that's what I was going to hit on here. Was that I was going to say. So in California, Prop 22 costs $205,370,000.
Mm-hmm.
59.5 DoorDash, 52.1, or that was Uber, 52.1 DoorDash, 49 Lyft, and then 31.6 Instacart and Postmates still a little bit. But that's not Uber.
Yeah.
Right, but is that? Do you think that that's going to become a pattern for states then? Is that Uber and Lyft are going to move this thing and keep spending $205 million in every state?
Well, I think that not every state has a proposition system. So there are a finite number of states, and this is what they've been done. First, what they did was they tried to get all local regulation preempted. So in most states in the U.S., local regulators are not allowed to do anything. They're not allowed to touch Uber and Lyft. It's all done by state regulators. So in California, only the CPUC can do anything with regard to regulating Uber and Lyft, or the California legislature. Like the city of San Francisco, for example, can't say, we need emergency sick leave for these workers, because the CPUC preempts their ability to do any kind of local regulation. And this is true. They've done this all over the country. They have created situations where there can only be state regulation, whether they've done that through laws or what have you. This is what they've done. So now their next thing, now that they've created a legal environment in which they only have to deal with states, their next thing is to pass state level laws like Prop 22. And so they have this method going on in Massachusetts. They also have this going on in Ontario. This was just introduced in Ontario, in Canada as well. I think that they're trying something similar in Massachusetts. They've tried something similar in Connecticut. So anywhere that they see a threat to their business model, or they see legislators moving to provide workers any benefits like unemployment insurance, for example, they're going to try and introduce this. It's worth noting in New York State, Uber and Lyft drivers are employees for purposes of unemployment insurance. They get UI as a result of litigation by the New York Taxi Workers Alliance, and they're eligible for UI, which has been really, really, really important during the pandemic, because UI actually offers a lot more than PUA. It's like a significant, it can be up to, in California, it was up to something like $1,000 a month more. And in New York City, workers also have a wage floor. And there are some issues with flexibility. What they've done is basically made it difficult for drivers to get, if they're driving back into Manhattan, to get on. All of things that can be regulated for. They're doing it on purpose so that this model doesn't spread. But it is possible to have like unemployment insurance and a wage floor. And I think that what the drivers in New York City have pushed for and gotten is such like a beautiful example of really what is possible elsewhere, and they do not want it to spread. So they tried this in New York State also, as you know, and the effort was subverted in large part because drivers were going to have to give away these two things that they've won: unemployment insurance and a wage floor.
Well, I could add.
So that's the end of Veena, but I gotta say to that I know drivers in New York, and when this happened, the wage floor that she's talking about, I often refer to it as where the floor meets the ceiling.
Mm-hmm.
That wage floor was really all they could earn too. Wow.
Well, she mentioned pandemic unemployment assistance.
Yeah.
And do you know that she accused me of she personally accused me of libeling her? Did I ever tell you the story?
Mm.
She and her cohorts wrote this open letter during the pandemic to Congress saying that about the CARES Act, which was going to distribute, pandemic unemployment assistance to various people, including independent contractors. And she signed her name to a letter that was written stating that they didn't want anybody who they deemed to be misclassified to be receiving pandemic unemployment assistance, which could, she thinks everybody's misclassified, right? If you're an independent contractor. So I posted something to my group, and I said, look, Lorena Gonzalez's bestie, Veena Dubal, and her ilk are seeking to prevent independent contractors from collecting pandemic unemployment assistance. And I screenshot the passage and I circled the sentence. And she came back. I heard it. Somebody was following her, but by that time, most all of us were blocked by her way back earlier than before Prop 22 even was a thing, because she doesn't want to hear anything. She doesn't want to hear anything from the opposition. And so she said, "Oh, vicious fake information for her virulent people. Her representation constitutes the legal definition of libel. And I'm like, what? No kidding. So I had one of the attorneys in our group called me right away, and she goes, "Hey, if she does file a libel claim against you or lawsuit against you, we'll just file I'll work for you for free, and we'll file an anti-SLAPP motion, and she'll end up having to pay out tens of thousands of dollars to you because you are allowed, the members of the public are allowed to comment on political, something like a public letter to Congress, and then, but this was after when Prop 22, when they realized that Prop 22 was probably going to pass, she and her buddies got together in the media and decided to wage this campaign against all independent contractors, claiming that we were bought and paid for by Uber, that Uber had sent out were paying us to harass her personally. So all these it was like, what is going on? There was an article in the New York Times, there was an article in CNET, and she was naming independent contractors that you're aware of on Twitter as people who were harassing her publicly, but that Uber was paying us to do it. It was nuts.
I never really understood.
I only responded to one of her tweets way back early after AB5 passed, and she blocked me. And that was, she tweeted, "The short-term pain from the labor shakeups across hundreds of industries will be worth the recentering of worker power." That was her tweet. And I responded with a photograph of Nurse Ratched, and she blocked me, And she was very, very antagonistic with all the freelancers, saying the same types of things, calling us hysterical, telling us to get over it. It's exhausting. She brought it on herself, because she was a spokesperson. She's the go-to person. She's not just somebody sitting up in a little, ivory tower, ivory tower of academia, not directly involved. She is the go-to person for these labor reporters to interview anytime there's any kind of article about quote unquote exploited workers and Uber and Lyft and all the rest. I mean, she is a public figure, and she was, like I said, she was intricately involved in the Dynamics decision because they cited her in their decision.
Yeah. I don't know. I think it was frustrating because I'll go back to I think she knew more. I really do. I think there were times during that discussion where she knew things that we weren't, like even the 2257, just the little things.
Well, I heard her actually.
I think that's what it was called. That stuff was blowing me away.
I think it was. I heard her say that Uber and Lyft passed Prop 22 themselves. I had to raise my hand when she said that, but no, the voters passed it. So I don't know if she's just misspeaking and or trying to pull the wool over your eyes, or what.
Well, I mean, I think that I don't know. I think we were on the same page that it was voted on.
Right.
So we definitely were not talking about Uber passing it. We discussed that it was voted on.
I don't take issue with the fact that her lane is rideshare and delivery and talking about these platforms and, whatever her viewpoint is about them. What I take issue with her is her dismissive attitude of haughty disdain toward everybody, all the dolphins in the tuna net, and all of us freelancers and independent contractors and small business people and entrepreneurs and self-employed individuals who've been harmed by this law, the way that she just dismisses it and says it's hysteria. And she says it over and over and over again, and she doesn't have the wherewithal or the desire to listen to understand the full ramifications of what these labor laws bring, because to her and people like her, the collateral damage is acceptable. It's like you said, it's acceptable.
Yeah.
And she doesn't think it's real or whatever, but that's why she was getting backlash on Twitter, because she kept tweeting those kinds of things over and over to people and making these kinds of statements, and people who had just lost their livelihoods and their careers were just like completely offended by the notion that we were making all of this up. And she just doubled down and tripled down on all of that, and she continues to do that to this day.
Yeah, I don't have a problem with the way that she views things either. I just have a problem. I guess my issue is the way she explains it.
I
Like,
think
too often my brain feels like it's being sliced in half by a razor blade.
Well, if I recommend that you read that wage that paper of hers, because I'll tell you what, she actually wrote something that made it sound like, here, let me see if I can find it. Here it is. She says, Nicole Moore, a Lyft driver and organizer with Rideshare Drivers United, a statewide group of self-organized ride-hail drivers, described Prop 22 as as part of a lineage of racial exclusion from state worker protections. So she quotes Nicole Moore. Prop 22, plain and simple, puts all of us app-based workers in a second-class worker status permanently, historically. And just like domestic workers and farm workers, we're a majority people of color and immigrant workforce. And somehow people make up lies that it's okay for us to not have access to the same protections and wage floors as everyone else. Nicole Moore is not a person of color, and she makes six figures with the county of Los Angeles.
Yeah, I think you're not supposed to know that.
Well, it's
I mean, I do. I think that's the kind of thing that you're not supposed to. She just figures most people won't look into that.
But it's duplicitous. In her paper, she actually pretends like this person that she's quoting, who she's actually really organizing with behind the scenes, doing all these protests and all the various different things that they do, is a person of color. And that their uprising was organic when it was organized by big labor. They're organizing.
Yeah.
Rideshare Drivers United. And Nicole Moore is assault.
Yeah.
Assault, meaning just like that guy Lee with Dynamics. There are people that the SCI. I will say, I think she's probably assault. Yeah. Why would she be driving for Lyft if she makes the kind of money she does with the county of Los Angeles?
Well, I don't think she drives anymore.
Well, she's still being quoted. She and Veena Dubal are the people that are always quoted in all of the major media stories about any labor exploitation issues around ride hail and any other kind of, Veena ventures out and thinks she knows what's going on with the journalism profession, which she doesn't.
Yeah.
So, that she kind of sets herself up as somebody who should be unapproachable and not, I just don't understand why she doesn't want, if you're really serious about crafting labor law that's going to help everybody and not hurt so many people, you would want to see what the unintended and intended consequences of this law is. You would want to know about it.
Yeah.
I would think. I would.
Yeah.
That's why I read her. That's why I read some of her papers and I listened to some of her interviews. I want to hear what they have to say, because there are other points of view.
Yeah. Yeah. I mean, that's why I had her on, is because she did have a completely different point of view than me, but I wanted to understand it better, but I don't think she did the best job explaining it.
Well, I think, unfortunately, that academics like her inform the labor movement, and they're using critical race theory as a wedge to I mean, that's just my feeling about it. She said let's see. I got to read this to you. I can't find it. Oh, I'll find it in a minute. Oh, here she said. She said that academics like herself are a subjective people. This is a quote. They are a subjective people who shape and engage the world with everything we write and everything we say. Wow. I bet you she's never held an actual regular job outside of a college campus. Same with Lorena Gonzalez. These people don't know what it's like to run your own business or to work your way up from the top, as a worker, because they are in their own sort of, tunnel vision, lofty perch.
I don't know. I do know that it took, I know it was just recently. It was when you, Kim, and I did something, and Mike a few, like 6-7 weeks ago. That's when I finally got blocked by Lorena.
Yeah.
She had blocked me up until then. I'm kind of I was kind of like, part of me was kind of like, yes, I finally made the group. And part of me was like, why'd you wait till now to block me?
She doesn't want to hear any. I don't know. She must have seen something and came.
I think that she was like, he's not offensive enough yet, and it's still a window for me to peek through to see his tweets.
Well, congratulations, you joined us. But she's talking about all of us freelancers in my group and people on Twitter. She was blocking us way before.
That's what I mean.
And she blocks people. There's a whole bunch of people that would say, gosh, I got blocked by her and I've never even engaged with her or heard of her at all. So I think anybody that has any viewpoint that's different than hers or comes from what she views as the evil freelancer against AB5's side is somebody that she does not want to engage with.
Yeah.
And she thinks that we are dangerous people. Somebody doxed her address, but I think, and it was one of the people on Twitter. I think she was an interpreter, but only to show that she lived in some Tony neighborhood in Silicon Valley. Not that there was going to be pitchforks and protests and people burning her house down or anything like that. I wasn't a part of any of that. I have rules of engagement in my group. And you have to sort of.
For all you know, she had somebody do that anyway.
Yeah, she made. They decided that, like I said, when they realized Prop 22 was going to pass, they had to figure something out. So they did this shock and awe campaign accusing our freelancer movement of personally racially harassing her and being influenced and paid for by Rideshare, which was just absurd. I mean, I've never talked to anybody in Rideshare other than a couple of drivers. I do know the person. Joe was asking about Olson versus the state of California. I do. Lydia Olson is a member of my group, and that ruling, Veena Dubal wrote an amicus brief or participated in an amicus brief against it. The Ninth Circuit ruled that Lorena Gonzalez was, backroom dealing and behaving badly and had blatant animus against Uber and Lyft, and that the exemptions were arbitrary and didn't make any sense, and that they probably AB5 violates the 13th Amendment. I mean, the Equal Protection Clause under the 14th Amendment and all the rest. I mean, it was a really scathing ruling. It named Lorena Gonzalez by name 14 times for all of her bad thuggish behavior. And so there was finally a glimmer of hope, that a court, a panel of 3 judges at the Ninth Circuit were seeing AB5 in the same way that we all see it. It's like unconstitutional, and it picks winners and losers, and it violates the Equal Protection Clause, and it was aimed at Uber and Lyft and everybody else's cotton tuna net.
Yeah. Well, and that's one of the things that I was asking her too, was that, wasn't this initially meant at the gig app-based platform, gig economy, and again, it was an I don't know answer. Those I don't know answers really rubbed me wrong. I don't know. I just felt like I didn't care what her answer was, but I just didn't like I don't know. Like, just be honest with me.
It's better than her spouting something that's completely false about something she really doesn't know anything about, like opera.
Yeah.
Well, I mean, what she said about jail, it just was so laughable. That we talked about that in my group when we found out that she had said that. There were a bunch of opera people that came in and go, "What? What is she talking about? That is absolutely nuts. It's not possible. It's not. So clearly she hasn't really read the law. She doesn't know the fine details of the law that she's touting out there. She's only focused on gig drivers. That's her sole focus, seems to me. Yet she's de facto spokesperson for defending AB5 in the media. I'll hear her solace.
To those that don't know, do you want to tell everybody about your group so that people can come find it?
Yeah, Freelancers Against AB5 is a public Facebook group that I started right after the law was signed. So it's been 4 years now that I just had my 4-year anniversary with the group. I started on November 19th. And I started it to see what other people from other professions might have to say about how the law is affecting them. And we have close to 18,500 members, and most of them were, independent contractors and small business people and anybody that's affected by the law. And we have all sorts of conversations, about specifics of the law and, but the main thing is people telling their stories. And so we've identified 600 categories of professions that have been harmed or affected in one way or another at some point or other by AB5. And I archived all the stories that kept pouring in. I still get them, and I put them in that little archive that you brought up. Mm-hmm. And also I've focused on businesses, small businesses that are under audit, because those are the real horror stories of AB5. It's not just about independent contractors. It's about businesses that are getting audited for the crime of having an independent contractor, videographer, photographer, or an architectural renderer, or a music teacher, or, I have all sorts of people that have come in and told me their stories about how they're getting audited by the EDD and subjected to just a range of astronomical fines and penalties that can include up to $25,000 per violation for willful misclassification. And it's enough to put people out of business. And I've got people who've told me their audit stories, just small mom and pops and single person businesses who've been put out of business because of the audit for something that they had a mutual arrangement with somebody who had their own equipment, made their own hours, set their own rates and everything else. And they still got audited and they still got fined. So, and what we're hearing now is that the EDD is just ignoring the exemptions altogether. They don't care that dog walkers got an exemption. If you pull up that archive, the story from the dog walker just came in just a couple of weeks ago, and they got fined $100,000. And dog walkers have an exemption. They got fined $100,000 for 4 dog walkers. I mean, hello. And then there was another guy that came in. This is crazy, Steve. He was a trucker. He had a little small family fleet. And because AB5 is now in effect on trucking, he got audited for the years 2020 through 2022 and had to convert his drivers to employees, or maybe not. Maybe he had to let them go. He got fined and penalized. And I wrote him back and I said, you have to be mistaken, because there's a preliminary injunction on the trucking industry, from 2020 to 2022 while they fought it out in the court. So truckers could remain independent contractors and not have AB5 enforced against them. And he said, no, their audit was AB5. I was audited under the ABC test of AB5. And I said, are you sure it wasn't Borello or Dynamics or what? And he showed me his paperwork, and it clearly said that he was audited under AB5 and the ABC test of AB5. And I'm like, did you have an attorney? And he goes, no. And I said, you need to contact the California Trucking Association and tell them your story, because if they're pulling that kind of shit, these auditors don't even know who's exempt and who is.
My guess is they don't anyway.
They don't care now. They told the dog walker. The dog walker said, "Do you know that we're exempt from AB 2257, the cleanup bill?" And she goes, the auditor told her, I don't know anything about AB 2257. And they said, okay, well, go Google it and look it up. And she looked it up, and clearly dog walkers are exempt. And she said, it doesn't matter. We're fining you $100,000 anyways.
I mean, but here's the other thing. Just to point it out, the people that they're fining these $25,000 per instance, they're not going to pay those fines. They can't, and they're not gonna.
Well, they're for taxes. So if you don't pay, if you declare bankruptcy on those kinds of fines because you can't pay them, they'll put a lien on your assets. They'll put a lien on your house.
It's like a student loan. It's like a student loan.
No, they'll go after you. There was a woman who got, and I mentioned this before in one of the previous podcasts, but she had a quadriplegic adult son, and her other son was the owner of the company, but she signed the checks, and they told her she was going to owe $700,000 in back taxes and benefits for just 2 independent contractors that they used off and on. And these independent contractors had their own equipment. They set their own hours. They had their own rates. They just uploaded their video footage to our platform. And she said, I can't pay this. And the auditor told her, well, we're going to put a lien on your mobile home, which is all outfitted to take care of her quadriplegic son. And they would put a lien on her handicap van for her son that was like an $80,000 van. They would put a lien on that. That's how the state of California treats small business people. And the independent contractors themselves, they didn't want to be employees. One of them already had benefits because he was a retired military in his 70s. I mean, these are the kinds of outrageous, horrible stories. And she told me I wanted her to, allow me to tell her story. And she says she was just too traumatized by it all. Gail, she told us that she got a letter from the EDD saying she owed $25,000 for a independent contractor that she paid $610 to.
Mm-hmm.
$25,000. She said she got a letter. She was able to get that, erased or whatever. But I mean, can you imagine what? So that's why there's a chilling effect in California on independent contractors altogether, because even if you have an outright exemption, there's still the stories that are coming into our group is that these businesses are getting penalized anyways, and they're ignoring the exemptions.
I mean, there's got to be some kind of legal challenge you can have to these audits, though.
You can appeal them. But they're payroll tax audits. If the Division of Labor Standards Enforcement comes in and they have their own separate penalties and fines for other things, like what that to do with wages and hours, and then workers' comp, the Workers' Comp Appeals Board could fine you $10,000 for not providing workers' comp. If your independent contractor is misclassified, and they're all in cahoots with one another. All these different agencies, they can work together to really bring down the hammer on a single business or an industry, so there's this whole posse of enforcers. And so who in their right mind is going to want to hire an independent contractor in California? Because the law, when you read it, it's just so convoluted. Like, it's still like, if I wanted to, something that I used to do on the side was to help my friend who had running events. He would have 10K running events, and he would have me come out, me and my friends, we would come out and we would either hand out bib numbers or hand out the awards or do the timing or whatever. and you pay to be you pay that with a 1099. But there's no pathway in AB5 for somebody like that because you're not customarily engaged and you're being controlled and directed by the race director. So who's going to be able to, these little event planners are really struggling under AB5 because they can't put everybody on payroll.
Right.
I mean, why would they? Why would you put somebody on payroll for 2 hours worth of work once a year at the turkey trot in Dana Point? Why would you do that? But the single engagement event exemption does not allow for that particular contracting arrangement. Well, it would probably fly under the radar when all is said and done, but still.
So I see there's a comment from Joe Beth that one woman who EDD said owed $700K. They only employed contractors with LLCs, business licenses, press cards, etc.
That's correct. She knows who I'm talking about. These people were not employed. They were independent contractors. There were 3 of them. One of them was a young kid who waited until he turned 18 so he could take his video camera out into San Diego and shoot footage and then upload it to their platform. All they were a platform where you upload the video, and news organizations would, purchase that. And he was making, $8,000, $9,000, $10,000 a month as an independent contractor when he finally got, and the other guy was in his 70s, and he just wanted to stay active in his sunset years. And they had their own press credentials, like Joe Beth said. They had their own equipment. They picked and choose wherever they wanted to go, whatever they wanted to do. They charged what they wanted. And yet this woman was on the hook for $700,000. And she wasn't even the owner of the company. She just signed the checks because the law says that you can go after certain people, stakeholders in the company. You can pierce that veil. And it's a very dangerous thing, She actually ended up passing the audit when all was said and done because they backed off. And there was an EDD auditor that was in my group. Her name was Cheryl, and people were like, "She's a plant. She's in here looking for misclassification violations." And I said, no, I want to talk to her and see what she has to say. So I talked to her, and she said she was in the group because her husband was a real estate appraiser, and AB5 was completely and totally destroying his business, and they didn't have an exemption at that point. And that she herself personally thought it was a completely ludicrous law, and that they didn't even know how they were even going to approach an audit. But she'd been with the EDD for many, many, many years. And she actually was in one of the departments where they would oversee abuses by EDD auditors. And I told her the story about the woman with the video platform and the quadriplegic son. And she said, that is something that we would, that my department, when I was ahead of that department, would investigate and put the clamp down on an auditor like that.
Yeah. Well, clearly, if in any way you think this is a good law, or you think it won't come to your state, it could. I would say join. I would say check out Karen's group for one, but also we've recorded some other pieces that you can go back and listen to too about the just nightmare of AB5, and so.
One thing, if I could, I didn't mean to interrupt, but to make this relevant to your listeners across the country, is that these ABC copycat sorts of bills are appearing in other states, and you also have to be on the lookout now for the USDOL is going to be finalizing a regulation, a rule under the Fair Labor Standards Act that would restrict severely independent contracting, and they're about to unveil that rule any day now. Yeah. So you watch the shit hit the fan. There's going to be a whole lot of lawsuits and everything else. So they're coming for you. They don't want, like what you're saying, they want to squash that trajectory of the independent workforce, and especially in the gig economy. But unfortunately, they can't just, focus on certain industries like janitorial and, where there is a supposedly abuse, and agriculture and gig platforms. They have to, toss everybody overboard in their pursuit. And there's reasons for that. And it's because of unions.
Mm-hmm. Yeah. You guys, we've run a long time here, so thank you for sticking with us, or thank you for popping in or watching on the replay. And I want to thank Karen for her time too, as always. And that's all I got for today.
Steve, thanks for having me on. It was
Yeah.
It was fun to listen. Well, I can't say it was fun to listen to her, but you know, we listened to her. We listened to what she had to say. I wish she would listen to what we have to say. Yeah.
Well, maybe she'll see this or hear this.
Who knows?
So again, if she does, Veena, it was for your benefit as well too. So
yeah,
just maybe help you understand the other side of it too.
Right.
Because there's a complete other side. So
yes. Yeah, it's a very complicated situation, and it affects a lot of people across the board. Yeah. And when you have a law like this that does so much damage to so many people and is so destructive, it can't possibly be a good law, and it can't be the way forward, because if it were, then it would really be spreading across the country. So the fact that AB5 is such a disaster in California is kind of a firewall for other states. They're like, well, we want to address misclassification, but we don't want to do that, you know, because we're the canary in the coal mine here. Unfortunately, it's too late for us. It's just death by 1,000 cuts.
That's why I hope at some point somebody repeals this stupid law, because I mean, other states shouldn't be looking at this. It's not like you're going to learn something from this and go, let's just tweak it out a little. You can't just tweak it out a little. They tried AB 2257, and it's still a mess.
Right. I think it's important for rideshare people who don't understand the origins of Prop 22 to really look at what AB5 is really about and why it was important that they were allowed to remain independent contractors, even if everything else about it, some of the other things about it, are disappointing.
Yeah, I agree. And I like I said to you in the beginning, most people that I know, even in California, really don't. When I say, okay, well, even if they say they do benefit from Prop 22, when I say how, or do you know why you even get Prop 22, they say no. They have no idea what AB5 is.
Right.
Maybe they've heard it, but they don't know what it is.
Yes, on Prop 22 campaign, didn't they actually even mention the words AB5? They just talked about, we want to remain independent contractors in our industry, you know? And so there's just so much confusion and Prop 22 is not the same thing as AB5 and vice versa. And Prop 22, I mean, really, I think they just should have made the proposition to be about independent contracting and leave it at that, and not, write an entire new labor law around it, because there's bound to be problems down the line with what they're promising. But I guess they felt that they had to do that, and they were probably pressured by the Democrat elite in Sacramento to come up with that, because all the Democrats elite were working on Prop 22 behind the scenes. As I pointed out, Tony West, Anthony Fox, LaFonza Butler, Valerie Jarrett, David Plouffe, Barbara Boxer. Barbara Boxer was a former California U.S. Senator. She was on the advisory board with Lyft and was against AB5 and was promoting Prop 22 until AOC called her out on Twitter and started eviscerating her, and she backed down. But the Democrat elite are the ones in Silicon Valley who are behind the scenes of the inner workings of all of this. Prop 22.
So people be warned. You're not, nowhere's a safe haven, I guess. Although Texas seems to be one for all you California people that are moving.
Keep your labor laws out of Texas. That's probably what they're saying.
So thank you again for joining us. Thank you, Karen, for your time. And
thank you, Steve.
We'll see you guys soon.
Bye.
Bye, everybody.